Yes, well, I have a matter to this hearing, this item 7. I am extremely sorry, it somehow escaped my notice today. Can I be accommodated for some kind of Monday or Tuesday, any day?
Monday and Tuesday will not be possible. We have other cases.
Any
2 weeks. You're there. In 7, you write Mr. B. Talukdar, learned amicus curiae appearing for the appellant in this case has expressed personal difficulty and has personal difficulty to argue the matter today and has sought adjournment for 2 weeks. Full stop. Considering the ground on which the prayer is made, same stands allowed. Let this matter be listed. Then you write Miss M. Burman, learned amicus curiae, appearing in item 6 is present. In view of the prayer made by the learned amicus curiae, comma as noted above, comma, let these appeals be listed together for hearing again after 2 weeks. After 2 weeks.
Okay.
My lord, I mentioned that my 3 mandate. Item number 3.
Yes,
I will take the matter after weeks and mandate.
as paid for by appellants, as paid for by applicants counsel, applicants stroke appellants counsel. This matter stands adjourned for 2 weeks. List
Ma'am.
accordingly.
I am not blessing.
Exactly, your lordship. I beg to mention item number 4 and 5, lordship. We have taken consent from the other side, lordship.
He's not keeping well, my lord.
The learned counsel for the appellant in item 4, case number 2, 6, adjournment of the hearing of this case on the ground that the learned arguing counsel is unwell. Full stop. Since the prayer is not opposed, it stands allowed. Ms. K. Devi, learned counsel for the appellant in item 5 is present. Full stop. On the request of learned counsel for the appellant in item 4, let both these appeals be listed again for hearing after 2 weeks.
Highly obliged.
Obliged.
Item 1, lordship wanted the medical report of Amir Hassan as on 2nd of this month. That medical report is here. Harry, Maitri. That shows he was admitted on 24th. He was admitted on 24th. And then it was found out that he was admitted for chest pain and
Admitted
dizziness.
where?
24th of December.
Where?
He was at Lakhimpur Medical College. Thereafter, for chest pain and dizziness and with high blood pressure, that report is there for your lordship's perusal. I have taken out the prints.
Only one copy is there. Only one copy is there. Here's the other copy. Actually.
Lordship will see the first letter, that is a communication. Second one, Amir Hassan is examined today at 10 a.m. in Lakhimpur Medical College and Hospital. He is a known case of essential hypertension and lumbar spondylosis. He was admitted in medicine department on 24th of December for chest pain and dizziness with high blood pressure. He was discharged after his symptoms resolved and blood pressure was controlled. He has been on antihypertensive drugs, so-and-so 5 mg and so-and-so. His health status as of today is as follows. His conscious oriented pulse is 90 per minute. Regular BP is 190/90. Chest is clear and no leg swelling. In view of his high blood pressure, he is admitted in medicine department, Lakhimpur Medical College Hospital for monitoring and management. Thereafter, there is another letter. He was on 24th below, was brought to the casualty department, Lakhimpur, with complaints of so-and-so. At present, his BP was 186/83. And pulse is so-and-so, 114 per minute. He was admitted in male medicine for evaluation and treatment, main medicine ward. He was evaluated for cardiac chest pain and found to be negative. He got better and his BP was controlled. He was discharged on 27/12 with diagnosis of accelerated hypertension and following advices. These are the medicines given. He was there in the hospital for 3 days.
He was discharged and again because of his health condition at night time, he was shifted again to the hospital, my lord.
27th, he is discharged.
Discharged, again he is admitted on now second. He's presently also in hospital, my lord.
He is in the hospital.
Hospital that I have today confirmed again in the morning. His son has stated that on 29 or 30 was at night immediately brought back. At present on second, the report reveals he is presently also in hospital. His BP is, my lord, the day he was released, his BP was 187. Since it was less than 190, they released him. Again, it increased at night, and then he was even given some high measure. My lord, I'm not injections in the bed, for which it immediately decreased down. Then thereafter again it rose, my lord. My lord, here, my lord, with due respect and with due honor, my lord, here.
No, bail will not grant.
My lord,
That
here-
will reject if you press. Because if he is having a health issue, then we'll get him treatment.
my
What
lord,
will you do with bail?
my lord,
He has to get treatment only.
my lord, treatment, my lord, here, my lord, my lord, with due respect, my lord, I'd like to place one discussion, my lord, if my lord permit.
No,
My
no,
lord,
you
on
want to
medical
place
grounds,
what?
on
You
medical-
want to
on
place what?
medical grounds. Because on merits,
See,
the bail was,
this,
my lord, I admit,
These technicalities will not work here.
my lord, on.
Medical ground bail can be granted if the facts so justifies.
My lord, here,
His problem is he is having high BP.
my lord,
If he is having high BP, it is required to be treated in a hospital.
my lord, here.
That we are providing
my-
for.
My lord, for some time, my lord, for at least interim, my lord, here, my lord, I just place one decision, my lord, may kindly permit.
Yes, you do it.
My lord, with due respect. My lord, here in this case, my lord, my lord, here in the Supreme Court judgment, my lord, on medical grounds, my lord, here the sections were not given. So, my lord, I have respect to the judgment on this, it has come before the Supreme Court. My lord, it is with regard to a judgment of the Bombay High Court where he was slight revision under section 364, 385, and 34. Here, my lord, here, my lord, at paragraph number 5, my lord. And the
So Ms. Zahar, she says he was again readmitted.
That report, the first letter shows that this is the status as of 2nd of January.
where he is
Today is
admitted, my lord.
5th. That 2nd of January letter doesn't show that he is admitted again. Now, he might be admitted because off and on his pressure increases, decreases. But then he's getting the treatment in Lakhimpur. Here, the judgment that she has shown, here, what kind of medical emergency, it's not reflected. In certain cases where treatment is available only in some specialized hospital, there, of course, interim and all are granted, bail is allowed. But here is a case which is normal and it can be treated in Lakhimpur Medical College. I leave it to your lordship, but otherwise, 65 years of age, he's already having hypertension and lumbar spondylosis. Pressure gets off and on increased or decreased. So he is being taken to hospital. He was there for 3 days. And again, if he was admitted, I don't have that knowledge. They did not tell
The
me.
report of the second, my lord, is reflected on 27, he was released, my lord. There, my lord, exact date I forgot, 29 or 30 at night, he was admitted, taken to hospital, returned back, and again second, my lord, may kindly see the first report. We take a report.
Do we take her his first letter? First letter on what is saying, with reference to the subject, I have the honor to forward.
Look, my lord, the BP, my lord, with due respect, he has started, my lord, on last occasion has seen the reports. His vein and everything of the one side has become blocked. My lord, on last occasion has perused the report in which it has clearly stated. My lord, in certain cases, my lord, only, my lord, critical illness does not show that only those are in high BP is a case where anytime my lord stroke may also, my lord, admitted for some treatment is given. My lord, sometimes the treatment, my lord, this case may be considered, my lord, with, my lord, his two sons are in jail, my lord, one due
You don't argue as if He is your uncle, it's not
No,
the
my
case.
lord. My
You
lord,
argue
at
on
this
legal
case-
points,
My lord,
because the whole country will come and say, I have blood pressure,
no,
I
my
have
lord,
high-
it's blood
I
pressure.
have spondylitis,
It was
let me
being
go.
conveyed By something on last occasion.
See,
my
the
lord.
point is, if we can show that he needs a treatment
My lord,
which is of emergent nature, which cannot be given to him in Lakhimpur Medical College,
my lord,
then we'll certainly consider,
my lord, in this
not by
case,
any other
my lord,
means.
in this case, his BP, 200, 190, this is not a normal BP, my lord
Hmm.
is aware of that, right?
Yes.
Continuous treatment is going on along with him, it
Hmm.
has been, so it
This will
reflects.
go on for another 5 years. So he will be on bail for 5 years.
No, my lord, at least for 13 period, my lord. My
So
lord,
make out a case.
my lord.
You are not making out a case.
My lord, I am with regard to.
You are
only the
making out a case for treatment, which they are
My-
giving.
Treatment, my lord. At
See,
the
Miss
last
Borua,
my lord, at last moment.
Please,
this
please
far,
understand, don't be emotional.
Yes.
You are a counsel.
Yeah.
Please understand the issue here.
My lord.
You came before this court seeking interim bail on medical ground,
My lord.
correct?
My lord,
Your regular bail application has been rejected,
my lord,
correct?
correct.
So as insofar as merit is concerned, the chapter is closed.
My lord, my lord.
What is the ground for seeking medical bail on medical ground? That he is having high BP
My lord.
and lumbar spondylitis. The spondylitis is obviously
No,
not a life
And one
threatening.
more, my lord, which
What?
one of the veins completely got blocked, that report was before your lordship on last occasion. I said,
All right, all right. We had asked the jail superintendent to immediately send him to Lakhimpur Medical
No.
College, and if the facilities are not enough, he should be brought to the Guwahati Medical
No.
College. So they did it. He was given some treatment, and the doctors found that he was
My lord,
now fit. He was sent back. The blood pressure is not a ground to grant bail on medical, release him on bail on medical ground. If you say that he is suffering from some ailment which requires immediate, which is life threatening, which requires immediate medical intervention at a higher center, higher level of facility, then of course we can consider.
my lord.
But just because he has some ailment, he is 65 years old, he will have some ailment. Then the law has to be that everybody who is 65 years old should be allowed to go on bail on medical ground. Can you think of a 65-year-old person who will have no medical
My lord,
issues?
that is-
So you have to make out that case. You are not being able to make out that case.
my
You
lord,
should persuade us to give
my lord,
your client the bail. The facts which are placed before us is not persuasive enough.
my lord,
And we have to maintain consistency.
my lord, my lord.
If we start granting medical bail on hypertension, it will create a massive chaos. And he is accused of a very heinous offense,
Yes.
302.
My lord,
We can't have this kind of an approach.
my lord.
So you make out a case and you get an order. You're not making out
My
a
lord,
case.
He don't have any other illness other than to be admitted position, I forgot the medical terminology with regard to the.
Hypertension, lumbar spondylosis.
What is that? What is the other?
That LVD.
Oh, that is
Yes.
What is it?
vascular disease where
Something-
arteries
Block.
gets blocked sometimes.
Yes.
LVD,
Yes.
it was last occasion,
On
no?
last occasion. It was before.
Can you tell us
now-
whether he's suffering from any cardiovascular disease?
But then today's report said chest part is okay.
No, LVD, my lord, on last occasion, it came from the medical board itself, my lord.
Heard Ms. S.G. Borwal, learned counsel for the applicant, also heard Ms. S. Jahan, learned APP, Assam appearing for the state. The learned APP has produced the report dated, report of the jail superintendent furnished in terms of our order dated 22/12/2022.
Cardiac chest state we have to-
From a perusal of the report
Ah, it was
forwarded
yes.
by letter dated 2/1/2022, we find that the applicant was admitted in the Lakhimpur Medical College Hospital on 24/12/2022 for chest pain and dizziness with high blood pressure. But after the health issues were resolved, controlled, he was released from the hospital
Hypertension.
on
LVD.
27/12/2022. full stop.
Hypertension,
As per the
LVD.
report,
lumbar spondylosis.
as per the health status report of the applicant, forwarded by the jail superintendent, district jail, Lakhimpur, it appears that the applicant is having high BP, but his chest is clear and there is no leg swelling. Full stop. Full stop.
Peripheral.
Mere hypertension and lumbar spondylitis, in our opinion, do not justify release of the applicant on bail on medical ground unless it is shown that he is suffering from emergent nature of health condition which calls for better medical treatment, nursing and care. Stop, full stop. At this stage, Ms. Borua submits that that after release of the applicant on 27/12/2022, he was readmitted
My lord,
in the hospital
My lord.
again on
my lord, date, my lord, date I forgot, but presently also he is admitted, my lord.
and even today he is admitted in the hospital. Full stop. According to the learned counsel for the applicant, the her client is suffering from cardiovascular disease
No, my lord, it is reflected in your lordship order dated
with,
22/12. It
with
is
symptoms of
left heart.
blockage in the artery. Full stop. Therefore, submits Ms. Borua. This is a fit case to allow the applicant to go on bail, go on interim bail, at least for a period of 2 months, so as to enable him to obtain avail better medical facility. Full stop. Ms. Jahan, learned APP Assam, has however submitted that she does not have any instruction as regards readmission of the applicant and the fact that he is suffering from any cardiovascular disease. Full stop. In view of the above, and in order to take a final decision on the bail application, we direct the jail superintendent, district jail, North Lakhimpur, to have the health status of the applicant reevaluated and forward a fresh medical report indicating as to whether the applicant is suffering from any cardiovascular disease, and if so, whether such disease creates a threat to his life. Full stop. Let this, in the meantime, necessary medical treatment be provided to the applicant as per our earlier order. Full stop. List this case again on 24/1/2023 so as to enable the learned APP to obtain necessary instruction / report.
My lord, it is not, my lord, is left ventricular dysfunction, the word
That
terminology.
is
My
a heart
lord,
disease
my
only.
lord has used
Left ventricular
dysfunction.
Dysfunction.
dysfunction,
This is where part of the heart does not work properly.
posing a threat to his life, posing a threat to his life.
Lodge.
Next one.
Supplementary list for hearing, item 8, starter pattern.
Yes.
Lordship, I have prepared a note, Lordship.
Yes. It is that seizure of cannabis from the railway station.
Lordship.
What are the main grounds
Lordship, I have mentioned in this note.
No, you tell us. First, you tell us what are the main grounds.
In this case, Lordship, only 6 witnesses examined. 5 witnesses are examined, Lordship. Among these, Lordship, only 3 and 4 is the main. In these 2 witnesses, there is.
What are the main grounds?
That is why, Lordship. Among these 2 witnesses, there is no corroboration. This is in the under NDPS Act, Lordship, if information received, this information received from PW4.
With the NDPS. NDPS.
PW4. Then Lordship, PW3 arrived at place of occurrence. Then it is regarding that there is contradiction, Lordship. Receiving of the information, there is contradiction. That is one of the main important point, Lordship. And after receiving the information from PW4, one GD entry prepared. Into that regard, there is no corroboration, Lordship. And under NDPS Act, if any investigation start on the basis of the information, in that case, that must have to reduce into writing as per section 42. Section 42 of the NDPS Act, Lordship.
Yes.
Then to that regard, Lordship, don't
Let
they
us see section 42.
42, Lordship. It starts from 41, procedural, Lordship. Then 42 is 41 is regarding authorization, Lordship. 42, Lordship, power of entry, search, seizure, and arrest without warrant and or authorization. May I read, Lordship?
Yes.
Number 1, any such officer being an officer superior in rank to a peon, sepoy, or constable of the departments of Central Excise, Narcotic, Customs, Revenue, Intelligence, or any other department of the central government, including paramilitary forces or armed forces, as is empowered in this behalf by general or special order by the central government or any other such officer being an officer superior in rank to a peon or sepoy or constable of the revenue, drugs control, excise, police, or any other department of a state government as is empowered in this behalf by general or special order of the state government, if he has reason to believe from personal knowledge or information given by any person and taken down in writing that any narcotic, drug, or psychotropic substances or controlled substances in respect of which an offense punishable under this act has been committed, or any document or other article which may furnish evidence of commission of such offense, or any illegally acquired property, or any document or other article which may furnish evidence of holding any illegally acquired property which is liable for seizure or freezing or forfeiture under Chapter 5A of this Act is kept or concealed in any building, conveyance, or enclosed place, maybe between sunrise or sunset, entered into and search any such building, conveyance, or place, or in case of resistance, break open any door and remove any obstacle to such entry, seize such drugs or substance and all materials used.
All right, 42 has nothing to do in your case. What is the next point?
Madam, 42 is applicable, Lordship,
Why?
because we got the apex court judgment, Lordship, because first is the constitutional judgment 2009 Colonel Singh, Lordship. If any information received, in that case, they must have to reduce into writing as per this reason, if reason believed from personal knowledge or information given by
Possible.
2009. 9.
Has it already been given?
It is not the same, Lordship. We have the copies.
You have the copy.
Copies, Lordship. Colonel Singh to the Adjournment. Thereafter also 2013, also the constitution was 13 to the 13. It is referred. It was a kind of thing.
Paragraph,
My lordship. Next up,
you have to hurry up a little bit, Miss Nargis.
lordship,
Otherwise, we'll have to postpone it. You have to hurry up a bit. There are a lot of work.
lordship.
Hmm.
Lordship, I have prepared these things, lordship.
Which is the judgment you want to rely upon?
Lordship.
You don't know which judgment you want to rely upon.
Mhm. Mhm. May I place one more judgment, lordship, regarding 42, lordship? Because lordship, I have marked, but they have missed, lordship, 2016 11 SCC, lordship.
Yes. See, Miss Nargis, you
Yes.
take your seat. Let us, you make your preparation.
No, lordship.
How can you sustain the conviction? There is no evidence which shows that the seizure was made from these persons.
No, first thing is that it.
Who has seen them? Which is the witness who has deposed that the bags were recovered from them? Point out that witness.
Initially, it was the train passengers who had first seen them.
Hmm.
It was the public apprehended them. Then they informed the RPF who were there on the train duty.
Hmm.
He came. He found them. Then he brought them down from the train.
So therefore, please take your seat.
Uh-huh.
Hmm. Therefore, it is the third layer which has come in evidence. The public
Yes.
is not there, the RPF,
No, RPF person is there who was on train escort duty.
but he was
Yeah.
informed by someone else.
He was informed by someone else. The
Who is that
villager
someone?
said, or the train passenger said, inform. How he got the information is not very clear. I'll just read out the escort
No, but
party.
these are very, Miss Jahan will cut it short. She is not prepared, but we are prepared, unfortunately. We come reading the brief. There are two major issues here,
Yes.
or rather three. You please address the court on that. You see, the prosecution case, of course, there is some contradiction. One limb of it says that these persons were traveling in the BG passenger train coming from Dimapur, and the passengers have nabbed these two persons, apprehended them, handed it over to the RPF team.
Narayan, I think, Narayan.
Yes, the RPF team informed Narayan, who was in escort duty.
Huh.
When he came, the RPF team handed over the accused persons along with the 4 bags. Narayan then called up PW1, Mahesh, who is the
Constable, he was
he's
the
the inspector,
SI of
SI
Kamaikha outpost.
outpost. And at the gate, the 2 accused persons were handed over to Mahesh by Narayan.
By Narayan.
Correct. Please listen to the query.
Yes.
What happens is we have to move on. We are a little disappointed that Miss Nargis has not been able to come prepared, but nevertheless,
I'm sorry,
We
Lordship,
will-
but I prepared, Lordship.
not doing it.
But with the judgment.
now you
Lordship-
take your seat. We'll do your
Lordship,
work.
I'm
You take
sorry.
your seat.
One
take your seat.
minute, Lordship.
You take your seat now. You take your seat. Take your seat. So, first of all, there is no evidence to establish that these bags were actually recovered from the possession of these 2 accused persons. This is point number 1. Okay. Secondly, there is contradiction in the evidence of the prosecution witnesses. One witness has said, and we'll give you the number of the witness, that the bags were recovered by the RPF party. In the sense that they were caught red-handed along with the bags, 4 bags. And when it was opened, we saw that they were packets of cannabis, and therefore they were taken into custody and later on handed over to PW1, who was authorized by the officer in charge, and etc. etc. That is the other part. The other set of the other evidence is that they were apprehended by the public inside the train, and it is also said. One witness has said that the bags were found inside the train, but there was no passenger. Correct.
That one.
This is a material contradiction. One version says public apprehended, handed over to the RPF. The other version says they were found with the bags, or bags were inside the train, and there was no one else. Both these can't be true. Both of these can't be true. So therefore, it is a material contradiction. The fourth aspect is PW1 says that it was weighed by in a scale balance obtained from a private person, and it found to be 35 kgs. 4 packets, 35 kgs. The weight which was used was 6 kg. How do you measure 4 packets of contraband with a measuring 6 kg and come to the conclusion that it is 35 kgs? We have not been able to figure out. If you can throw some light on that, very good. The person who had measured it, there is doubt. One hand, PW1 is projecting that he has done it. Later on, he said that it was PW3 who has done it. PW3 does not come clean on that. Be that as it may. How do you measure 35 kg, 4 packets weighing 35 kgs by using a weight which is 6 kgs? So there is here also there is some material contradiction. So rest of it is immaterial unless you have evidence to show that the contraband was recovered from them, and the witnesses have come and testified to that effect. It is doubtful whether the contraband were at all recovered from them or not. If that is doubtful, everything falls. We dictate the judgment at 11:15.
No, let me
And
just
you
place
have-
it once.
Your part is over.
No, as far as contraband being recovered from them, I'll just place few lines. PW4 said that initially the public apprehended the accused, Lordship has seen, along with 3 bags at Guwahati station. And then he said that those bags were inside the train, it seems. because they apprehended them inside the train. So those bags were there inside. And then the escort party person, he came. On what information, that is not very clear. But PW3, he said, I was at train escort party and was traveling. When BG train came to Guwahati railway station, 12 persons caught the accused persons with 3 bags and called me as in charge of RPF escort party to search. Accordingly, I rushed. So he said 12 persons have caught 3 bags inside the train. He was informed, he rushed along with my staff. I found the accused held by the public and I opened the 3 bags carried by the accused persons which contained ganja. This is page 22, PW4, Narayan Das.
Yes.
So he rushed, he saw the bags along with the accused persons inside the train. I took bags with the accused persons, Kamaikha and and then I opened the 3 bags which contained ganja and accordingly I took bags with the accused persons, Kamaikha railway station and informed the GRPF. So he brought them down at platform number 4, the accused person as well as the contrabands. No, the incident occurred at platform number 4.
This is not corroborated to each other, no?
This is what the first step. Thereafter, he said, I informed the GRPF. And the GRPF person, Noor Muhammad is PW3. He said on that day I was on duty at night at 10 p.m. Kamaikha, he was posted at Kamaikha police outpost. I was performing duty. I know accused persons. On that day at about 4:30 when the BG was standing at platform number 4, then RPF called me over phone. That means this is Narayan. Called me over phone that 2 persons with ganja were apprehended by them. So this Narayan informed Noor Muhammad. He was at the outpost. So he came.
We are only asking one question.
Yes.
Show us, point out the evidence which goes to show that these 3 bags containing 4 packets of ganja was seized from the custody of these 2 persons.
Yes.
Where is the evidence?
This is what I can show from PW4. People have apprehended inside the train.
But Lordship, both the witnesses nowhere stated the name of the accused persons.
No, why don't you take your seat? We are
Okay,
asking you
I'm
to
sorry.
take your seat. You will have a lot of work to do now. Please get ready.
PW4 is my only recourse. PW4 said 12 persons caught with 3 bags and called me in as in charge of RPF escort party to search. Accordingly, I rushed to the spot along with my staff. I found the accused held by the public. Accused means the appellants. Held by the public, and I opened the 3 bags carried by accused persons which contained ganja, which was carried by accused person. And they were apprehended inside the train. First, thereafter they were brought down. This shows they were in conscious possession. They were the ones who were carrying those bags. 313 there is nothing. 313 there is. 313 he said that somebody else had told him to carry those bags. But in that defense, they have not said anywhere. They could have said to the authorities then and there itself. They did not say 313. Later at the stage of 313, they took that plea. So as far as their carrying is there, they had carried the bags.
Which is that
Otherwise-
paragraph in 313?
313 is there. This is first question. Answer to the first question, page number 26.
Yes.
A person asked me to carry a bag for him, saying that he would hire a rickshaw, and I was carrying the bag. The police apprehended me. He said I was carrying the bag. Person told me. And same is the case of with PW, the accused number 2. He also said, on being asked by a passenger, when I offloaded his bag, he gave me rupees 50, and about that time, the police apprehended me. When I offloaded his bag, he gave me rupees 50. And about that time, the police apprehended me.
This is by one of the accused.
This is by Ghosh. Appellant number 2. First one is by Malbar Khan.
And where is the 313 of Malbar Khan?
Page number 26. Oh, no, this, yes, Malbar Khan. Page number 26, first answer to the question, question number 1. Person asked me to carry a bag. Carry a bag. A bag. Into a bag contain 4 packets inside, no?
May I point out one thing, Lordship?
Yes. What do you want to point out?
313 will come subsequently, Lordship. Before that, they have to establish their case. Their foundational facts must.
Okay, you take your seat. You argue whatever you want to argue. First, you argue. Yes. You argue. You argue.
Lordship, if she complete, then I will.
No. Now you argue. You finish off
Lordship-
your part, then we'll ask her.
Lordship, what happened in this case? Caesar made. She has stated about the PW 3 and 4. Regarding that, Lordship, GD entry prepared, but GD entry says something else, Lordship. He has stated that PW 4 stated that after getting information from 12%, Lordship, he rushed to the place, rushed to PW 12% caught the accused person with 3 bags. Then Lordship called me as in charge of RPF in charge, he was called. Then rushed to the spot. He has not stated that to the train or to the platform number 4. But that is, Lordship, not corroborated with PW 3, Lordship. He has, the PW 4 stated that I took the bags with the accused person to Kamakya railway station and informed the GRPF. In cross, he has stated that initially the public apprehended the accused person along with 3 bags at Guwahati railway station, which is 13 kilometers away from the Kamakya railway station, Lordship. It is stated by the PW1, Lordship. And we also know Guwahati GRPS is here in Guwahati railway station, and Kamakya railway station is far away from Guwahati railway station, Lordship. Then it is not corroborated with PW3, Lordship. PW3 stated that I accordingly, in middle portion of his deposition, accordingly, I went to the platform number 4 and found the accused person with bags and caught by RPF personnel. RPF arrived at the spot. Accordingly, my in-charge reported SI Boisho, who came and took the accused person with ganja to the police station. He has stated, PW4 stated that he took the person to the police station and there he handed over. But PW3 stated that he's in charge and he went to the platform number 4. This regarding this place of occurrence is also not corroborated. But before that, Lordship, under NDPS Act, the foundational facts must have to establish. To that regard, if Caesar made and the 313 stated my learned friend, but the thing is that Caesar list must have to look into and GD&T, Lordship. In the Caesar list, nobody's name has been mentioned. No signature obtained from the accused person. That was recovered from his position. Kindly go through the Caesar list, Lordship. Page 51, Lordship. Though it is prepared, there is, in the original also I have verified, Lordship, no, nobody's signature obtained and that was exhibited during the trial. And no person's name in the body of this list, Lordship, from whose position it was recovered. That is the first document after receiving the information by the PW officer in charge, lordship. There is nobody's name in the seizure list. From whose position it was recovered, lordship? And this was prepared, but no witnesses except the officials, lordship. 12 person caught. That person also not interrogated by anybody, lordship. From where they have this accused person have been caught, lordship. And lordship kindly peruse the page 48, the GD entry. This is prepared by PW5. Here, lordship, he has stated N.M. Ali, who is on duty, informs our phone that escort in charge, Narayan Das and the staff of RPF who were on train escort duty have handed over to him two suspected along with bags containing some packaged ganja-like substances after apprehending them. Both the person handed over to PW5, he has stated. But PW3 stated that after getting the information, the person came to the platform, lordship. And PW4 stated that he brought the person to the police station. There is no corroboration to that regard, lordship. And the seizure list is the main thing, lordship. Thereafter, lordship, what happened? How many samples they have recovered? As per the gazette notification, lordship, I think last occasion I have placed, lordship. Gazette notification, lordship, 1/89, and recently on 23/12/2022 also one gazette notification published. As per the gazette notification, lordship, from each bag must have to obtain the samples, lordship. Whether it is ganja or something like contraband, lordship, that must have to follow, lordship. But in this case, as per the deposition and the exhibit, lordship, of FSL report, only one sample collected. From which bag it is not also ascertained. FSL report as page 54, lordship. At the last, lordship, one sample envelope marked as Exhibit A having a closed polythene packet containing about 24 gram dry plant material, Exhibit D1 392 2015, and that is cannabis, lordship. And the seizure was made on 29th, and it is received by office at the top, lordship, third line. This was received in this on 1/12/2015, lordship. Then for about from 30 to 1/12, lordship, where they have kept these samples under contrabands, lordship, that is also a great question, lordship. How they have kept the safe custody as per the, though it is not mandatory, lordship, but all the sections, and this punishment is very stringent. That is why all the section must have to follow scrupulously, lordship. That is as per section 55, lordship. It should be in the custody of the police officer, officer in charge, lordship. It should be in safe custody, lordship. That must have to establish by them, lordship. There are lots of judgment from our apex court, lordship. How they have kept under whose custody it was kept, lordship, that they have established. And in this case, how they have kept these things, that is not mentioned in anywhere. To that regard, the custodian like Sirastadar or like that, lordship, they are also not made witness and not examined by the prosecution, lordship. And the register, Malkhana register, MR register also not produced during the trial, where they have kept these things in the Malkhana or not. And the more important thing, lordship, PW1 exhibited, materially exhibited all the things in page 15. But he has not mentioned a single line that these things are recovered and it is in sealed pack condition with after obtaining the signature of the accused person. There is nothing, lordship. From their position, it was recovered that they have failed to establish, lordship.
Yes.
And 52, last occasion also I have mentioned 52A, lordship. 52A, after receiving all the things, and nowadays, lordship, it was mandatory after 2016, lordship, then they must have to collect it in presence of the magistrate. And thereafter, they must have to submit an application for correctness of the samples and the as well as the contrabands, lordship, which have recovered from the accused person. That formality is also not followed by the seizing officers. Seizing officer, he himself not weigh the things and seize the things, he admit in his deposition. Inventory must have to prepare by them after search and seizure as per section 42A, 52A. So that formality is also not, this is mandatory, lordship. Because it mentioned as shall in subclause 2. That is why independent witness, presence of independent witness is very much required, lordship. What I found in this case, lordship, there are no corroboration among the official witnesses. So they have not made an attempt to collect any independent witness and to search and seizure in presence of the independent witnesses.
Yes.
Lordship, lordship, this accused person, whether they were traveling inside the train or not, for that purpose also they have not collected any tickets from the accused person.
Well, they will not buy tickets and come.
But whether they were present in the Guwahati GRPS, Guwahati railway station or Kamakya railway station, that is not established. To that regard, they are contradicting. Because he himself, the person who first get the person, he is contradicting his own statement, lordship. First day he stated in his cross that he first got the person in Guwahati GRPS, Guwahati railway station. Thereafter, he brought the person to the Kamakya. Why he has brought the person?
So what do you have to say in that 313 statement?
Before that, lordship, these foundational facts, as per Nuraga case, also foundational facts must have to establish. If foundational facts is not established to that regard,
It's okay.
then 313 will come
All right.
later.
It is your submission.
Lordship.
Supposing we hold that the foundational facts have been established. We are entitled to hold that. Then
Lordship.
what is your answer to 313?
313, lordship, they have what they have stated. These are whether these persons are thumb impression person, lordship. This was asked, what the question asked, that was explained or not, I don't have any knowledge, lordship. Only stated a person asked me to carry a bag. There are 3 bags. A bag, which bag? That was not indicated, lordship. A bag for him saying that he would hire a rickshaw, and as I was carrying the bag, the police apprehended me. Which bag, lordship? This was not indicated. That was later on no question put by the trial court. Which bag? They have not met. This was materially exhibited. He could have asked the question, the material exhibit 1, 2, 3 like that, lordship. That was materially exhibited by the PW1. Question to sir.
Yes.
Next one, Lordship, this other person also, Ratan Ghosh, he also denied that false. He has stated a false first answer. Then on being asked by a passenger, when I offloaded his bag, he gave me ₹50 and about that time police apprehended. Which bag, Lordship?
They are in custody since the date of judgment.
Date of arrest. Date of arrest. Yes, yes. This is a commercial quantity, Lordship.
What is the date of arrest?
That is, date of arrest is, Lordship, 18, sorry, 14. Date of arrest is, Lordship, 29/11/2015. But seizure list, Lordship, I'm also astonished about these things that a police officer, sub-inspector level police officer made the search and seizure, Lordship. The seizure list at no point of time mention about the name of the person from whose position it was recovered, Lordship. And signature of the persons must have to obtain over that document, Lordship. That is also not done, Lordship. I've gone through the original also.
And Caesar witness is also not examined.
No. And independent witness. If there is no corroboration, there are lots of contradiction. In that case, independent witness is required, Lordship. This is, Lordship, that is judgment of regarding this 2020, Lordship, regarding this independent witnesses, Lordship. Linen Martin.
Yes.
Ma'am. Paragraph 5, 7 and 8.
Yeah.
Can
She's
we-
not- Yeah. Including. Including.
5, 7 and 8. Lord.
Paragraph.
5, 7 and 8, Lordship. Regarding this independent witnesses, Lordship.
Yes.
Some other judgment regarding this Lordship conditional facts and all, I can please Lordship. But other parts also Lordship notes samples not as per the Gazette notification 1/T9. Lordship from each bag, from one bag, from which bag that is also not established Lordship, and the Caesar list Lordship. And the other part Lordship, they are not corroborated to each other. GDNT also not corroborated to each other, and the PW5 is the investigating officer Lordship. To that regard, Lordship, PW5 also question also not asked from the side of the defense Lordship, but in this case also PW5 only he has submitted charge sheet, but regarding the safe custody of the older materials, that is also not mentioned in his deposition. and how he has kept the articles in sealed condition in the proper manner, lordship. That is also not established, lordship. And subsequently, lordship, regarding the section 57, so that is not mandatory, it's a directory, but it's one of the part of the lordship, the prosecution, lordship, that after all the formalities, lordship, he must have to place submit a report under section 57, lordship, within 48 hours. That is as per section 57, lordship. That is also not done by the investigating officer. Regarding lordship, independent witness, 2022 judgment also there, lordship. If lordship, can I pass? Lordship, it's paragraph number 4. I can't be sure.
Yes.
Lordship, let her finish. I'll place the judgment, lordship. I'm arranging it.
Now, Lordship knows that every case is dependable on its own facts. Now, it is no res integra, it's a settled position that independent witnesses are not always required to bring home the guilt under NDPS. The statement of the authorities are good enough, provided they are reliable. Now here, what I can see is there are no major contradiction as such. Here, Narayan Das was the first one to find out the bags as well as the accused, barring the public. And of course, he did not say it in so many words before the trial court that at what point, what was the spot where he recovered those
So
articles?
we are only asking, show us the evidence to prove the possession, that's all.
In fact, what he has stated before trial court is that the public informed him, 12 passengers caught him, public informed him, he rushed to the spot, and then he found the bags as well as the accused. By going to 161 statement, of course, that is not reliable, but to find out the actual fact, there I found he said that the train was running. When the public found out those articles, the train was running. He was inside, he was coming from Dimapur to Guwahati station. Now he was informed, he rushed to the spot, and there they found, he along with his other people, there they found both the accused as well as the bags. After that, when the train stopped at Kamakya railway station, he brought them down. That was in 161, not here. Here he says, I rushed to the spot. Now, which is the spot?
161 of PW?
Narayan, PW4. PW4. Here, Lordship will see his statement before trial court. I was a train escort, page number 22, party, and I was traveling in BG Express train from Dimapur to Kamakya. When the BG train came to Kamakya railway station, about 12 passengers caught the accused persons with 3 bags and called me as in charge of RPF escort party to search. Accordingly, I rushed to the spot. Now, what is the spot? He didn't make it clear. Along with my staff, I found the accused held by the public, and I opened the 3 bags carried by the accused person, which contained ganja, and accordingly, I took bags with accused persons at Kamakya railway station. If your lordship permits me, I can read his 161 statement once. Narayan Das. Narayan Das says, express train or train escort duty kori goi Punor Dimapuror par rati Guwahatile ghuri aho. Punor Dimapuror par rati praye 9:45 man bajat DN Express train khonot train escort duty kori Kamakya railway station oloi ahi thakute train khon Guwahati rail station rail station erar pisot. He says ahi thakute train khon Guwahati rail station erar pisot Guwahati aru Kamakya rail station or majot coach number so and so aji iman tarikhe pua praye 4:30 man bajat তিনিটা কলা বেগৰ থকাত মুঠ 4টা বেগ পেকেট ভিতৰত 3টা কলা ৰঙৰ আৰু গ্ৰীন কালাৰৰ it's so difficult to read হেউজিয়া পলিথিনৰ নাগিছ পঢ়িব হেউজিয়া পলিথিনৰ মেৰুৱা সন্দেহজনক গাঞ্জা
জাতীয় বস্তু দেখা
পাও
কিন্তু
অলপ সময়ৰ পিছতে ৰেল গাড়ীখন কামাখ্যা ৰেল ষ্টেচন আহি পোৱাত দুজন লোকে বেগ 3টা নিবলৈ ধৰাত তেওঁলোকক হাতে লুটে ধৰি ৰাখি কামাখ্যা ষ্টেচনত কৰ্তব্য GPF ষ্টাফক so and so গতাই দিও. So that time they were inside the coach and they were found out inside the coach.
So they were identified when they tried to take the bag.
That is what 160.
That is not telling me this.
This is, of course, not there in before this. He said, I came to the spot with my stuff and I found the accused held by the public. I opened and I handed him over. So the root of the matter is they were inside the train. Bags were with them. They were carrying. And then they were first apprehended by public. He was informed. He came. And he
The
says,
root of the matter means what we are asking you is the evidence has to be reliable. It has to be free from contradiction.
Yes.
although the contradiction has not been proved,
Hmm,
but the fact remains that the version given in 161
hmm,
is materially different from the version
Hmm.
given in his deposition. Here he says the public had apprehended, he was called
hmm,
and handed over.
hmm,
There he said the public has found the bags
hmm,
and he was waiting when these two people came to pick up the bags.
hmm.
Then he apprehended them.
No, what he said, public apprehended, thereafter he came. And when the train stopped at Kamakya station, they tried to flee, then I apprehended.
They tried to flee. Just read it once again.
Yes. Kamakya rail stationer major coach number আজি ইমান তাৰিখে ৰাতিপুৱা প্ৰায় 4:30 মান বজাত তিনিটা কলা বেগৰ সৈতে পেকেট কলা ৰঙৰ and all those এটা হেউজিয়া মেৰি থোৱা মানুহজনক জাতীয় হেৰি নাগিছবা এইটো কি জব্দ দেখা পাওঁ এইটো কি
গাঞ্জা
এই কি পলিটিনৰ
পলিথিনেৰে
মেৰুৱাই মানুহজনক
গাঞ্জা জাতীয় বস্তু
দেখা পাওঁ he saw inside the train
সন্দেহজনক গাঞ্জা জাতীয় বস্তু
দেখা পাওঁ he saw it inside the train কিন্তু না এইটো ট্ৰেইন চলি আছে চোৱা তুমি coach number so and so then he said দেখা পাওঁ কিন্তু অলপ সময়ৰ পিছত ৰেলগাড়ীখন কামাখ্যা ৰেল ষ্টেচন আহি পোৱাৰ পিছত দুজন লোকে বেগ তিনটা নিবলৈ ধৰাত তেওঁলোকক হাতে লুটে ধৰো but these two person he saw it beforehand Kamakya rail
So therefore, what we are asking you that as per his 161 statement, first he saw the 3 bags, which was pointed out by the public. When these 2 accused persons convicts came to take the bags, then he caught them. That is his version in 161.
Even I think when he reached the coach, he saw both the bags as well as the accused persons. Rajib, etu apon agoba bonason. Train escort Dimapuror
পৰা ৰাতি প্ৰায় 9:45 মান বজাত ডাউন ৰাজধানী এক্সপ্ৰেছ ট্ৰেইনখন এস্কৰ্ট ডিউটি কৰি কামাখ্যা ৰেল ষ্টেচন আহি থাকোতে ট্ৰেইনখন গুৱাহাটী ৰেল ষ্টেচনৰ এৰাৰ পিছত গুৱাহাটী আৰু কামাখ্যা ষ্টেচনৰ মাজত কোচ নম্বৰ জি 29/11/2015 তাৰিখে ৰাতিপুৱা প্ৰায় 4:30 মান বজাত তিনিটা কলা ৰঙৰ বেগত মুঠ 4টা পেকেট ইয়াৰ ভিতৰত 3টা পেকেট কলা ৰঙৰ পলিথিনেৰে আৰু এটা সেউজীয়া পলিথিনেৰে মেৰুৱা সন্দেহজনক গাঞ্জা জাতীয় বস্তু দেখা পায়
আৰু আছে না মেৰুৱা
মানুহ নহয় সন্দেহ
সন্দেহজনক
লৰ্ডশ্বিপ ইজ কাৰেক্ট
সন্দেহজনক আচ্ছা
সন্দেহজনক গাঞ্জা জাতীয় বস্তু দেখা পাওঁ কিন্তু অলপ সময় পিছত ৰেলগাড়ীখন কামাখ্যা ৰেল ষ্টেচন আহি পোৱাৰ পিছত দুজন লোকে বেগ তিনিটা নিবলৈ ধৰাত তেওঁলোকে হাতে লুটে ধৰি ৰাখি কামাখ্যা ৰেল ষ্টেচনৰ কৰ্তব্য
lordship is correct I thought that is
But Lordship,
that is সন্দেহজনক
161 is not relevant. 67 is relevant in under NDPS Act
No,
regarding.
yes, 161 is not, just to state the real facts, I just wanted to. In fact, yes, lordship is correct. He is not Manu, that's Hondejanak. In fact, they found the articles first. And when the train stopped at Kamakya, then these person were trying to flee with the bags. By carrying the bags, then they were apprehended. That part is not there in before the trial court. But then he was not declared that statement was not brought before during the cross-examination.
Put a marker on that page.
Yes. It was not brought before in the cross-examination. He was not crossed on that.
But in his 161, he says he was in the Rajdhani Express, is it?
He was coming from Dimapur to.
But in his deposition, he says he was in the BG Express.
He was in office, then he, after getting the information, he came to the platform number 4.
No. What lordship is
As per the PW4.
train as for duty.
Yes,
According-
when busy train came to Kamakya railway station.
No, he
above-
was traveling in BG Express
Not
train.
traveling in busy express from
Yeah.
Dimapur to Kamakya railway station.
It will BG Express train. This is what is written in 161 also.
But 161.
BG Express train. Honor. Train escort kori. Dimapur pa rati iman bajat. So and so ahi aslo. BG escort only.
We find there is a complete difference in version in the 161 and before the court. Maybe the contradiction was not proved,
Not proved.
but the court can look into the case diary.
To see the veracity of witness, one whole judgment I have, but no contradiction is not proved. We have to rely on this examination in chief. Examination in chief, he said he caught them. I found the accused. They were held by the public. I opened. I took the bags with the accused persons. No. As far as their carrying the bags, taking them down from the train, that is there in examination in chief. And he informed the GRPF. And thereafter he informed Noor Muhammad. Noor Muhammad came PW3. PW3 came, he was there at the site. And thereafter he informed Bosho. Bosho came and weighed.
That part is okay. That part.
Yes.
If we are convinced that the contraband was recovered from the accused person, then the conviction will be upheld. Rest of it is acceptable. You said the statement recorded under which provision is it?
67, Lordship. 161 is not relevant, Lordship.
Where is the statement under 67?
67 under NDPS Act, Lordship. First, after interception, they cannot arrest the accused person directly. Before that, Lordship, as 67 must have to follow, Lordship. Power to call for information, Lordship.
Power to call for
Information.
any officer referred to in section 42 who is authorized of a state permit during the course of any inquiry in connection with the comprehension of the information on persons of the purpose. Any person includes accused.
After
Examine.
42 or
Any person includes accused. You don't want a belek number person.
There is no statement under 67. This is to call for information.
Any person they
Lordship,
can call
if the
for.
officer work entrusted under section 42, Lordship.
No, he says he was orally authorized by the officer.
That is why, Lordship. But in that case, 67 must have to follow, Lordship. And nowadays, Lordship, after Tufan Singh's judgment, Lordship, 67 statement of the witnesses are not relevant.
See, this could have been a straightforward case. Get hold of one or two persons. It's a public place. There were passengers and so many other people in the platform. Get hold of a person or two independent witnesses, record their statement. And they could have come and deposed that these bags containing contrabands were recovered from these accused persons from their possession.
That would have settled the issue, but then.
You see, the problem is, that's what we keep saying. The matters which should take 10 minutes is taking 10 days because of the goof up by the they have no idea of how to conduct investigation. Prosecution also doesn't know. So
Even passengers would be reluctant to come and depose in an NDPS case. They are simply passengers, they go from here to there.
that's all right, but even the evidence is not consistent. They are giving different versions. What is the explanation for that?
This is the evidence he said in, of course, very small, very less words. People informed, he came, he rushed, and then he caught those persons, whether they were trying to flee or.
Of course, PW1 did not see anything, but his version is again very different. See what he says in his clause.
On the
Yes,
date
sir.
of incident, I was having duty at Kamakya outpost. The bags were handed over to me by GRP office Noor Mohammed Nayak and Narayan Das, 4:45 AM. As per Noor Mohammed and Narayan Das, the said bags were found inside the train having suspected ganja. During then, no person were inside train.
See how he contradicts now.
And just read out the
As per
original.
Noor Muhammad, the bags were found inside the train when there was no person.
Ah.
So his version contradicts the testimony of PW4.
How can there be no person? It's a train, it's a, people were coming and going. Perhaps by that time, everybody got down or something. I'll just, the original is also in English.
But Lordship, seizure list.
You are every time interfering.
Sorry, Lordship. I'm
What
sorry.
will happen is this matter has already got delayed. Just stop the live stream.
In fact, yes, the cross-examination, it is that said bags were found inside the bags, no person. Even in original, it is no person. Might be a case where ganjas were seized, people came down. Can be, I don't know, this is again
So that is
difficult.
why, Ms. Jan, we are saying show us that evidence which conclusively establishes that this is how the bags containing contrabands were recovered from the possession of this accused person. In all probability, that is what has happened. But then we have to go by what is on record. And then show us how the seizure list can be acted upon. It does not contain the signature or thumb impression. The seizure witnesses are not examined. There is doubt as to under what circumstances the bags were recovered, because the official witness is all right. You say that's the law. Official witnesses can be sufficient, but their evidence has to be found to be reliable. They are contradicting their version. And coupled with that, we don't know how this weighing business has been done. He
Weighing,
says,
yes, weighing, he said that there were 4 packets and
you
they
see
were
at
done
page
separately.
16, just see page
Huh.
16.
16 years I've
Yes.
seen.
See
The
the
seized
clause.
ganjas were weighed 4 times.
Hmm,
As there were 4 packets seized,
hmm,
using the seized balance scale.
hmm.
The weight used to measure the 35 kgs of ganja was 6 kgs.
How
So
will
at
you do
best
it?
it could be 24 kgs.
How will you do it? You tell me, how is it feasible?
If it is done
And he is the
separately.
person who says it was done in his presence.
Ah, yes.
So
It was a
there
6
is-
kg weight. At best, if they had weighed 4 times, then it would come to 25, not 35.
How do you use 6 kg weigh it 4 times and come to 35 kgs? Then
They have not
if
said
there
that-
were 4 packets, why you have taken sample from one?
He said each sample was drawn.
But
And
only
again-
one was sent.
One was sent FSL. Of course, there are judgments 52 to 57 are directory, not mandatory samples.
Forget
sampling
the
and-
52 to 57. You know that samples in one of the packets is contraband. What about the other 3? That would raise a question mark on applicability of commercial quantity.
And just by looking at it, one cannot say that it is same. They are same in each packets. But they have seen it and things are all same.
Simple things are made so difficult.
Mm.
In the High Court appeals, we have to be balanced in our approach.
Section 42 will not come. This is in fact a chance recovery, although my friend differs, but then it's not a case where information was given
No,
secret.
no, we have also said.
Yes,
42 has nothing
42
to
is
do.
not there. Only sampling I find, of course, there is a flaw. But then it's not mandatory if section 52 to 57 Supreme Court has said. 52 to 57.
No.
Gurbakh Singh says.
All right, we'll come back in 5 minutes and you want to add anything?
Correction what my learned friend said, but Gurbakh Singh, the Supreme Court said that section 52 is directory, not mandatory. Although police has to follow the procedures laid down, but violation of 52 itself will not result in any acquittal. That lordship can see Gurbakh Singh once. Gurbakh Singh is 2001, 3 SSC 28. 2001, 3 SSC 28. There, paragraph 8, paragraph 9 in Manupatra. It starts with the learned counsel for the appellant. Paragraph 9. Of course, in the facts of the case, that case is not relevant as far as my case is concerned now. In the fact of the case, they were held guilty. But as far as section 52 and 57, they are said to be directory in paragraph 9. The paragraph 9 starts with the learned counsel for the appellant. Did your lordship get?
Yes.
Yes. The learned counsel for the appellant contended that from the evidence, it is apparent that the IO had not followed the procedure under 52, 55, and 57 of the NDPS Act. Maybe the IO had no knowledge about the operation of NDPS Act on the date of incident as a recorded FIR under section so-and-so of OPM Act. In our view, there is much substance in his submission. It is true that provisions of section 52 and 57 are directory. Violation of these provisions would not ipso facto violate the trial or conviction. However, the IO cannot totally ignore this provision, and such failure will have a bearing on appreciation of evidence regarding arrest of the accused or seizure of the article. This is what
Let us see what is 52 and 57.
52 includes 52A. Yes. And 52A has come into force in 1989. 52A, lordship will go to subsection 2, clause C. 2 also is there, inventory and all. Where any narcotic drugs control has been seized, forwarded to officer in charge of nearest police station or to the officer empowered under 52. The officer referred to in so-and-so shall prepare an inventory of such narcotic drugs conveyance containing such details, description, quality, quantity, mode of punching marks, numbers, etc. Or the packing in which they are packed, country of origin, other particulars as the officer referred to in subsection 1 may consider relevant to the identity of the narcotic drugs control substance. In any proceeding under this act, make an application to any magistrate for the purpose of, lordship can go to, of course, 1 is inventory, 2nd is photographs, 3 is allowing to draw representative samples of such drugs or substances in presence of such magistrate certifying the correctness of the lists to be drawn.
So here no such application appears to have been made.
Those certification and all are not done.
And what is 57?
57 is report of the report of seizure or property of the person arrested by the notified officer. Whenever any officer notified under 53 makes an arrest or seizure under this act, the provision
You're reading 57A.
Oh, 57. I'm so sorry. 57. Whenever any person makes any arrest or seizure under this act, he shall within 48 hours next, after such arrest or seizure, make a full report of all the particulars of such arrest or seizure to his immediate official superior.
So no such report is there.
In fact, here the Bosho has immediately taken them to the police station and had reported everything to the senior officer in writing. In writing, it's not there, but lordship will see Bosho. He said, I handed over the accused person seized ganja and the samples being drawn by me to the in-charge Kamaikha GRP outpost and then lodged and written FIR of the outpost. That part is there. 57 is FIR. No, 57 is the report of the seized. Otherwise, he has given it to the senior officer in charge. There is one more, Gulbakshi.
So 59 also provides that the officer can be punished.
For any contravention.
Hmm. Yes, anything else you want to say?
Few judgments, of course, those chance recovery judgments I'm not placing anymore.
Hmm.
The same principle is also there in Balbir Singh's case 94-3 SCC 299, paragraph 25, where it is said 52 and 57 are again. This is 94-3 SCC 299. Same principle, 52 and 57 are directory.
That's all right.
That's Gulbakshi says.
No, but even if it is directory, the Supreme Court has said that the IO cannot totally ignore the provisions and failure will have a bearing.
Yes, we'll have failure. But sometimes in certain cases where it is, it will take time for the magistrate to come and all. In those cases,
But do you think this case falls into that category?
after it is seized, after it is handed off over to the in charge, they have enough time to follow all this. That is there.
There is nothing to show why the requirements of 52 and 57 would not be followed in this case. Maybe out of ignorance, but then if the law prescribes the procedure, it has to be followed.
In that case, they had registered it under the
If we
opium
continue
case.
to condone these ignorances, then the officers will continue to behave
Continue
like
doing
this.
it. That will not be fair.
Unless these are pointed out and some heads roll, they will not learn anything. There is no intention of learning. But anyway, we will have to go by the edict of law.
And there is a standing instruction which says that there has to be sample in from each and every packet. There is a standing instruction. But then I have a judgment, standing instructions do not have the force of law. But then again, Supreme Court said it needs to be followed at times.
No, but that's all right. The samples were definitely not drawn from the three other packets. Correct. So whether the standing instruction is followed or not, today you don't have any evidence to show what was there in the three other packets. That much has to be accepted.
Because
Even
simply
if it
by
is-
seeing one cannot say these are the same things.
Even if it is assumed that one of the packets did contain cannabis, independently the weight of each packet is not available. 35 kg is total. What is the independent weight of each packet? That evidence is not available. So the prosecution does not know what was there in the other three packets. What was the size of these three packets? There is no evidence. Then say, what is the commercial quantity for cannabis?
20 kg,
20
above
kgs.
20 kg.
Above?
Up to 20 kg, not cheap, small,
Medium,
intermediate quantity.
Above 20 kgs is commercial.
So 20 kg is intermediate.
No, above, lesser than 20 is intermediate. More than 20 is commercial.
So this provision 2B, 2C is for commercial.
Yes.
Yes.
Yes, sir.
Then that also how it is proved. 4 packets weighing for 35 kgs. Sample drawn from only one packet. What is the proof to show that that one packet was weighing 20 kgs? If it is not there, how this provision, the charge under this can be said to have been established?
Because they have considered 35 kgs in total. And
Right.
25 sample consist of 25 grams from
24
one
grams.
packet. 24
24.
grams from one packet. That is a sample drawn from one packet, send it for FSL.
Right.
Of course, what Bosha has said, each sample, each it seems there are more samples collected. But in FSL, they say it's only one. So they have taken the total amount of 35 to bring into. Let me see the judgment once, Lordship, if your Lordship desires judgment. I think paragraph 25,
Page number,
page number 42. Earlier paragraphs are also important, but 40, 24, 25, 24, further the evidence of PW1 shows that he found the accused persons were handed over to him by PW3 and 4 with the bags containing ganja. Now it comes to the notice that there is no evidence on record that personal search of these are not required. Personal search will not come into force. Personal search for a bag of also. Independent witness is dealt with in paragraph 22. This is Lordship is subtle. 23, it appears that PW3, that he was informed by PW4 about the apprehension of accused person with contraband articles. PW3 is the police constable. He apparently informed in charge GRPS. For conscious possession, I think he has not dealt with, denial that deployed. Lordship may see paragraph 18 for possession by the accused.
paragraph 18.
18. It is clear from the evidence of official witness needs careful appreciation to assess their credibility. From the case record, it appears that it was 4 who first detected the carrying of ganja by 2 persons, which were held by public passengers of the train. There is no denial of the fact that PW4 was on escort duty in BG Express, train running from Dimapur to Guwahati, Kamakhya railway station on the fateful day. PW4 belongs to RPF organization, which is deployed for the purpose of train security in general. Thus, he is not a member of local police. PW4 received the information that 2 persons were held up by local passengers for carrying suspected ganjas in their luggages. Once he got the information, he rushed to the spot and found the accused persons with 3 bags. Found the accused persons with 3 bags containing suspected ganja after opening the same, and he immediately informed the local police. This is what he has found, that he found them in possession.
No, who had called PW4 to the place? Who had called? Passengers called him.
Passengers, has to be passengers. Because he said, not in so many words, he didn't say. I was at so and so, and then about 12 passengers caught and called me. About 12 passengers caught the accused person and called me as in charge of RPF. The passengers called him. He was there inside the train. Passengers called me. Passengers. As far as Malkhana and all those findings are there at paragraph 29(5) of the judgment.
So PW4 had handed over these 2 persons along with the bags to whom?
PW3.
PW3.
First, Noor Muhammad.
Hmm.
Noor Muhammad is the RPF personnel. No, he was posted at Kamakhya police outpost. I was performing, I know on that day 4:30 when BG Express was standing at platform number 4, then RPF party called me over phone that 2 persons with ganja were apprehended by them. Accordingly, I went to platform and found the accused persons caught by RPF. I thereafter informed in charge of outpost immediately, and in the meantime, 1 inspector of RPF came. Accordingly, in charge Bosho came. So PW4 first took them down, informed PW3. And then PW 3 and 4 together informed PW1. PW1 said, on the day of so-and-so, I got an information from Nayak Noor Muhammad, who was in the night duty at Kamakhya railway station, that some ganjas were recovered. First, Narayan to Noor, Noor to Bosho. Bosho got authority letter and he came.
So basically it is PW4,
Basically,
there is
PW.
nothing else.
Hmm.
So question is, does the evidence of PW4 establish
Hmm.
that the contrabands were recovered from their presence, from the possession of the accused persons?
Hmm.
Let us see what 20 B2C says. Charge is under section 20, small b, small Roman 2,
Hmm.
capital C, is it?
B possesses. 20B includes possesses. And then charge quota B2C. 2 is B2. Where such contravention relates to subclause B and involves commercial quantity with rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to 20 years and shall also be liable to fine. Whoever in contravention of any provision of this act or rule. This is the charging section. And 29 of NDPS. 29 of one conviction. 29 conspiracy. Oh, acha, acha. 29 is punishment for abatement and criminal conspiracy. Conviction is only under C. $29 to conviction is.
Conviction is read with section 29.
29. 29 is
So
conspiracy.
before going to 29, 20B,
Huh.
here it will be either possess or transport.
Huh.
So to transport also possession has to be shown.
Yes, it's all comma.
Yes.
Hmm.
So basically possession is a sine qua non.
Ah, yes.
It has to be shown.
Hmm.
Now let us come to 29.
Whoever abates or is a party to a criminal conspiracy to commit an offense punishable under this chapter shall, whether such offense be or may not be not committed in consequence of such abatement or in pursuance of such criminal conspiracy and notwithstanding anything contained in 116, be punishable with the punishment provided for the offense. Conspiracy. Mechanically delaying. There's no finding. No.
Okay, now what is the commercial quantity here?
Lordship will go to the schedule. No, the schedule গুলো বলুন, cannabis? 20. Cannabis, নাকি? Oh, no, কি বলি আছে এটা? Cannabis, this is গাঞ্জা বেলে কেছে? গাঞ্জা এখানে লিখা আছে রিপোর্টে। কিন্তু এটা 1 kg আছে? 1 kg আছে। Ganja to velek nahi hota hai. Ganja is separately given. Ganja is 20 kg. Lordship will the
Where does one find it?
Lordship 1, 2, 3, 4th page in the schedule. Or the back of the paper of the book. No, cannabis and cannabis resin. Charas hashish. It is charas hashish. Ganja is differently given.
So schedule
Ganja is
page
serial number 55.
1 minute. Last.
At the last part of the book. Back side of the book, Lordship.
Is 188.
Table is there. Ganja is a small quantity is 1000 gram, no? And small quantity, oh, 1 kg, yeah. And more than 20 kgs, it's commercial.
Where is ganja? Which page?
Serial number 55.
55.
It will be the 4th page of the schedule.
Alphabetically given.
Alphabetic.
So small quantity will be up to 1000 gram.
1
1
kg. From 1 kg to 19 kg, something will be intermediate. 19.9 kg.
And 20 kg will be.
Will be commercial.
So what is the finding of the trial court as regards the involvement of both the accused persons? Let's read from para 26.
26, yes. From the above evidence of prosecution witnesses, it is clear that 35 kgs of ganjas were recovered from the accused persons, carried in 3 bags, which was duly seized by PW1. It is correct to say that no journey railway tickets were recovered by PW1 from the accused person, but the accused persons were caught with huge quantity of contraband ganja from railway station platform and by railway passengers initially. Therefore, it is a special knowledge of the accused person regarding not possessing any rail tickets under 106 of the Evidence Act. It is the burden of the accused person to prove the fact why they were not in possession of journey railway tickets. That again, they go on to
No, that's not correct.
Then 27, from the statement of accused person under 313, it appears that accused person took the plea that some passengers asked them to carry the bags under pretext to call a rickshaw, and in the meantime, the police caught them. They denied the possession of the bags containing ganja. Neither they wanted to say that they had no knowledge of contraband kept in the bags. Thus, it is the burden of the accused person to prove that they were not in a mental state to commit such crime as alleged by the prosecution. It is probable that they may be right, since no rail tickets were recovered from them, which indicates that they might not travel by BG Express train on the fateful day. But the version of 1, 3, and 4 does not corroborate the above claim of the accused person. The evidence of PW4, it was that some passengers who caught the accused person for carrying the bag suspiciously, and thus it was informed to PW4, who was in the escort duty of BG Express train. Had there been another person involved in trafficking of ganja by train, the accused person ought to have reported it to PW1, 3, and 4 immediately. But the evidence on record does not disclose so. If they were the railway porter, they ought to have produced the relevant documents to show that they were in conscious possession of the contraband ganja. It is Baldev Singh, it was held that physical possession of the contraband by the accused has been proved. Section 35 of NDPS Act comes into play, and the burden shifts on the appellant accused to prove that he was not in conscious possession. In the instant case, also the evidence on record proves clearly that the accused persons were found in illegal possession of 35 kgs of ganja, which were seized from the possession containing in 3 bags. The plea so taken by the accused persons to prove that they were not in conscious possession of the seized ganja, but the accused persons failed to adduce any evidence to draw a different view from the prosecution case. Hence, there is no bar to presume under section 35 that the accused persons were consciously possessing the seized 35 ganja or kgs of ganja carried in 3 bags. Thus, from the evidence of record, it appears that both involved in trafficking the contraband ganja, and they agreed to conspire. This is what section 29. Agreed to conspire to commit the crime together, but caught red-handed. It is correct to say that there is apparent lapse in the investigation of case, but in so and so it was held that advancement of technology and availability of high-speed exchange of information, some of the provision has to be read in the change context.
No, that is difficult to agree with.
Section 35, Lordship, and C1.
They agreed to conspire to commit a crime. What is the evidence to show that?
Conspiracy cannot be direct evidence here.
No, but indirect evidence has to be there. What is the evidence?
Evidence, the only evidence is people had seen the bags there. They were carrying the bags.
3 bags. Who was carrying which bag? That evidence is not there. Can one person carry 3 bags? No.
No.
2 persons were carrying. Then
In-
somebody will have to carry 1, somebody will have to carry 2. Where
Because
is that evidence?
they were altogether 4 packets, 3
Hmm.
bags.
Hmm.
So,
We'll go to the packets later on.
uh,
Packets were inside the bag.
hmm.
But there is no evidence who was found in possession of how many bags, what was found inside that bag. It might so happen that the bag found in the custody of one person, there was no contraband.
Such
All
minor
these
details are not
possibilities-
there, but
Huh?
one was carrying 2 bags, one was 1 bag, that is what
But
we
the
can
charge
presume.
has to be proved. The
Huh.
conscious possession has to be established. To do that, it was very plain and simple for the prosecution or the IO to prepare a report on these things, and the witnesses, forget the independent witness, the official witnesses could have come and deposed to that. It appears that something is very hazy here. Somebody is either unaware or not sure what has happened, or
But carelessly done, I mean, without any details.
trial court
particulars.
has also held that there were lapses in investigation.
Hmm. So they took recourse to section these availability, technology and all, some has to be waived.
What has that got to lapse in investigation? What is
That judgments I have brought, Bahadur Singh judgment, Lordship will see, Bahadur Singh judgment I have referred. Bahadur Singh is 2010 4 SCC, yes, 445. Assessment. Paragraph 9, 12 and 13. 2010 4. Paragraph 9, this is non-compliance of 57. 10 and Lordship will go to paragraph 12. It cannot but be noticed that with the advancement of technology and the availability of high-speed exchange of information, some of the provisions of NDPS Act, including 42, have to be read in the changed context. Apart from the views expressed in Sajjan Abraham's case, that a delay caused in complying with 42 could result in escape of the offender or even removal of the contraband, there would be substantial compliance. If the information received were subsequently sent to the superior officer, in the instant case, as soon as the investigating officer reached the spot, he sent us wireless message to Deputy Superintendent of Police, which was his immediate higher officer, and subsequent to the recovery, a RUCA containing all the facts and circumstances of the case were also sent to police station from the spot from where the recovery was made, on the basis of where whereof of FIR was registered and copies thereof were sent to Ilaka magistrate and also to higher police officers. It was held by the High Court that there was therefore substantial compliance of 42 and no prejudice was shown to have been caused to the accused on account of non-reduction of secret information into writing or non-sending of the same to the higher officer immediately thereafter. Paragraph 13 also, apart from decision of Sajjan Abraham, the decision of Constitution Bench in Karnal Singh has also made it clear that non-compliance with 42 will not vitiate that. 42 is okay. As far as 57 is concerned, as has been indicated earlier, it has been held by this court that same was not mandatory, and in any event, information of the arrest of the petitioner and the seizure of contraband had been duly reported to the local police station on the basis of which FIR has been drawn up. So certain clause here and there has to be again read in the context.
That is all right. That is all right. We have to harmoniously construct and interpret the provision. But again, coming back to the same area, what is your answer to that? Finally, this is the final opportunity. We say that we'll of course give it a second thought and see what can be done here. But the fact remains that the provisions are stringent, therefore the case has to be proved strictly. The first and most important part here is to prove the conscious possession. The prosecution case is 3 bags containing 4 packets. There are different versions. There is no clarity on exactly how and where from and under what condition the bags were recovered. So if that is not there, the evidence to prove the conscious possession of the accused obviously will not be there. It is not only possession, conscious possession. That has to be seen in the light of the explanation furnished by them. Then, of course, as we indicated, 3 bags, 2 accused. Who was found to be carrying which bag? Then samples, then the measurement. How could they measure 4 packets with a weight balance of 6 kgs and come to the conclusion that total weight was 35 kgs? What was the weight of the individual packets? That is not there. These are relevant because they have not sent samples from the all 4 packets, and the commercial quantity will be 20 kgs and above. And of course, the seizure does not appear to be in accordance with law. Seizure witness is not examined. Signature, thumb impression not taken. No report presented, etc., etc. So after PW1 takes over, then it's fine. But then unless they were really found to have been carrying this baggage, how can we say that a conscious possession is established? What do you have to say on that?
The only answer I would give, there are cases where the police officers get secret information and then they seize. In those cases, strict following the provisions are required because they will know what to do and what not. Here is a case where the person who had seen first was simply a train escort party. He doesn't know. He said that my duty was only to go from Dimapur to Kamakya. He doesn't know anything. I cannot expect him to know all these.
No, they are not on any procedure by him. He could not say under what circumstances the bags were seized. That's something as a witness he ought to have said.
As a witness, he of course said, not in so many words, but he said, 12 passengers caught him, informed me. I went, I rushed to the spot and I found them. I brought them down and I had informed the RPF people. This is the only thing he said. This shows that they were in possession of these bags, not someone else was caught. These two people. This is the only explanation.
10 minutes to you. Conclude whatever you have to say, 10
Lordship,
minutes.
regarding this notification in the judgment, Lordship, to 52A and last paragraph, Lordship. Though my learned friend stated that it's not mandatory, but it's a last paragraph, Lordship. It is summed up, Lordship.
Which page?
Lordship, last page, Lordship,
You are referring to the judgment.
judgment, Lordship.
Can you give us the paragraph number?
Paragraph 30, Lordship,
Paragraph number 30.
Lordship.
30 is not last paragraph.
31, sum of, Lordship, 31-1. It is a latest judgment 2016, thereafter, Lordship, it has been changed. The Mohanlal judgment, Lordship, regarding 52A. Inventory must have to prepare, and thereafter regarding the supply and disposition.
The sampling has to be done under the supervision of a magistrate.
Lordship.
And this is provided by this guide notification,
Yes, Lordship. This notification is, I have
which is the relevant.
relevant, Lordship.
It was,
Huh?
it was
It was 50, it is in the act itself, Lordship,
52A.
52A. And first, Lordship, 24 gram from each packet, Lordship. At page 4, the para 2.3, Lordship. Regarding this ganja, Lordship. The quantity withdrawn, each sample for chemical test, Lordship, got it. Test shall not be less than 5 grams in respect of all narcotic drugs and psychotropic substances, save in cases of opium, ganja, saras, where quantity 24 gram in each is required for chemical test, which is not done in our case. Then paragraph number 3.3 also.
Three point.
3.
Yes, what does it say?
Such go down, 3.2 says all the drugs invariably be stored in safe and vault provided with double locking system. Agencies of central and state governments may specifically designate their godowns for storage process. The godowns should be selected keeping in view their security and angle, just the position or to the course. 3.3, such godowns as a matter of rule shall be placed under the overall supervision and charge of gazetted officer of the respective enforcement agency, who shall exercise utmost care, circumspection, and personal supervision as far as possible. Each seizing officer shall deposit the drugs fully packed, sealed in godown within 48 hours of such seizure, with a forwarding memo indicating NDPS crime number as per crime and procedure under the new law, name of the accused, reference of test memo, description of drugs, total numbers of packages, containers, etc. Then 3.4, the seizing officer, after obtaining an acknowledgement for such deposit in the format X1, shall have acknowledgement over such or to the investigating officer of such along with the case desired for further proceedings. Then 3.5, the officer in charge of the godown before accepting the deposit of drugs shall ensure the same are properly packed and sealed, and he shall also arrange the packages / containers for quick retrieval. The godown in charge is required to maintain a register wherein entries of receipts should be made as per format act. Then Lordship, 52A at 4.4. As per this, the Mohanlal judgment passed, Lordship. Then Lordship. One 2029 SCC, Lordship. And Noor case, Lordship. Noor Aga case. In this case, Lordship, paragraph number 8 and 8, 9, and 10 regarding 35 and 54 Lordship. Position.
Yes,
The Noor Aga. In the Noor Aga case, paragraph number 58 Lordship.
no, you just referred to Gangadhar versus State of MP.
In this paragraph number 8, 8 and 10 Lordship, 8, 9, and 10.
Yes, why have you referred? You placed the paragraphs.
Yes, Lordship. In this paragraph, Lordship, the presumption against the accused of culpability under section 35 and section 54 of the Act statement conditions as satisfactory are rebuttable. It does not dispense with the obligation of the prosecution to prove the charge beyond all reasonable doubt. The presumptive provisions with reverse burden of proof does not sanction conviction on basis of preponderance of probability. Section 35(2) provides that the fact can be said to have been proved if it is section 35(2) provides that fact can be said to have been proved it is established beyond reasonable doubt, not on preponderance of probability. In 9, that right of the accused to a fair trial could not be whittled down under the act considered in Noor Aga case in paragraph 58. An initial burden exists upon the prosecution and only when it is stands satisfied would the legal burden shift. Even then, the standard of proof required for the accused to prove his innocence is not as higher as the prosecution, whereas the standard of proof required to prove the guilt of the accused on the prosecution is beyond reasonable doubt, but it is preponderance of probability on the accused. If the prosecution fails to prove foundational facts so as to attract the rigors of Section 35 of the Act, the actus reus, which is possession of contraband by the accused, cannot be said to have been established. Then 59, with a view to bring within its purview the requirements of Section 54, elements of possession of contraband was essential so as to shift the burden on accused. The provisions being exceptions to the general rule, the generality thereof would continue to be operative, namely the element of possession will have to be proved beyond reasonable doubt. Then the stringent provisions of NDPS Act, such as Section 37, the minimum sentence of 10 years, absence of any provisions for remission, do not dispense with the requirements of prosecution to establish a prima facie case beyond reasonable doubt, after investigation only, whereafter which the burden of proof shall shifted to the accused. The gravity of sentence and stringency of the provisions should therefore call for a heightened scrutiny of the evidence for establishment of fundamental facts by the prosecution. In this case, Lordship acquitted the accused person. Appeal.
Which case?
In this case, Lordship Gangadhar case. And the same, I have, that is why I referred Nuraga case before your Lordship. In this 58 and 59 is there, Lordship. Fifty-eight and 59 Lordship, in Nuraga case. Case 450. Dina, asal.
Yes.
Lordship, then 2011, 11 SCC paragraph number 5, Lordship. Regarding this safe custodian or Lordship.
Paragraph 5.
Paragraph 5, Lordship, last portion, Lordship. Need you always know. नाही आता दिश.
Yes.
Then some more judgments, Lordship already
Oh, don't just give us judgments unless it is of some.
Lordship.
All right, so that's all. Heard Miss Askin Argus, learned
If
counsel.
the Lordship allows me, as far as 35 kg is concerned, Lordship may just go through the Caesar list once at page number 50 and 51. If it at all throws any light.
Hmm.
50 is the Caesar list of the balance. There they say that they have seized articles, 2 numbers of Dagapala, 1 kg and another 5 kg. So there were 2, 5 and 1 kg.
Hmm.
Then the next page, page number 51, it says that they have seized 4 packets like ganja wrapped in 1 packet black color polythene and 3 numbers of packets wrapped with green color polythene. After weight, the same is found as 35 kg. Lordship will go to the description below. 3 numbers of bags containing 4 packets like ganja weight is, first packet is 7 kgs, 6, perhaps 5, 6, 7 kg. Second is 10 kg, third is 10 kg, and fourth is 8 kg. 39 is wrongly written. It is 35. How they have done? Difficult to gauge. There are 2 balance. There are 2 what we call weight.
Hmm.
5 and 1, 6 kgs in total. 7, they had separated the ganja or something. This, but then,
So with a 1 kg and 5 kg, how do you measure a packet weighing 7?
7 kg or 8 kg.
Or 8, 10 kgs or 8 kgs?
They have done something, but they have not explained.
All right, we'll proceed then.
One judgment is there if Lordship wants to see, no memos and including Caesar memo prepared at the spot, Lordship. As per the notification, it must have to prepared at the spot, paragraph number 2.1 or 2 like that, Lordship. If Lordship wants to see.
Heard Miss Askin Argus, counsel appearing for the appellant. We have also heard Miss S. Jahan, learned APPSM, appearing for this slate. Arguments concluded, that judgment reserved. Very good, Yusuf. Which paragraph of this?
Lordship, I think Lordship, I have highlighted Lordship, 5 or 8 like this.
Apply to this. किताब भी दीजिए किताब
Offline.
call it.
I can do.
Lordship, I need some more time. I'm not fully prepared to the Lordship. Maybe after beautification, Lordship. I don't have the paper book, my lord. They have, informant has also received, but I do not have the paper.
Ms. B. Sharma learned you are appearing in
Yes.
amicus curiae submits that he is not prepared to argue the matter today, and therefore this matter be listed after the upcoming Bihu holidays. Full stop. Ms. B. Bhuya learned APPSM also submits that she has not been furnished with a copy of the paper book. Full stop. Mr. S. Datta learned, your legal aid counsel.
Yes.
Legal aid counsel is present on behalf of the informant and confirms receipt of paper book. In view of the above, let this appeal be listed for hearing again after 2 weeks. In the meantime, office to furnish copy of the paper book to the learned APPSM.
My lord, one item of part 2 list 69, Lordship.
No,
We are
we'll
not
go
there.
serially.
LCB.
No, we'll go
we-
serially. We'll
Lordship.
go serially.
7 is there.
What is your number?
7, my lord.
You are ready to do it. Then we'll have to go serially.
In default, 3 months of SI That is the, my lord, sentence, my lord. Here, my lord, there is no eyewitness, my lord. There is no direct witness. The entire case is based upon, my lord, circumstantial evidence. And here, my lord, the moot questions to be, my lord, looked into. The moot question to be looked into, my lord. Whether, my lord, the deceased was died due to the injury caused by the accused by the piece of stone, or the deceased was died due to fall on the heel pota. So due to fall on the heel pota as a result of epilepsy. Because all the witness, my lord, deposed, my lord, he has been suffering from epilepsy. And my lord, he has, my lord, there is several instances that on many occasions, the deceased, my lord, under the attack of epilepsy, he fall on the street, on the market. That type of evidence is available in this, my lord, case, my lord. So first, my lord, I would like to read the FIR, my lord. Lord, it starts from page 4, my lord, of the paper book.
Yes.
Studio insert, Selanghat Police Station, date 16/11/2015. Sir, humble submission is that I am a permanent resident of ward number so-and-so, Selanghat Tea State, under the aforesaid police outpost. I would like to inform you that at a certain time in the night of 15/11/2015, a quarrel took place between my second brother, Sri Radhanath Tati, and youngest brother, Jagannath Tati, over some matter. And that my second brother, Sri Radhanath Tati, has confessed before me that he killed Jagannath by hitting him on his head with a method used for grinding turmeric. My lord, here, my lord, this FIR was written by one some Nogen Kandho, my lord, Kandho, my lord. And the whatever, my lord, statement is written, whatever has been written in this FIR, that has not been supported while, my lord, the PW, the informant was examined as PW1. My lord, he has not even deposed that in his evidence that he has confessed his evidence as confessed that he killed Jagannath by him on his head with a method used for grinding turmeric. Here in this case, my lord, the after investigation, police case was registered under section 302. Police, my lords, after investigation, submitted charge sheet under section 302. Thereafter, charge was framed. And in this case, my lord, as many as 8 witnesses were examined, including the official witnesses. PW1, my lord, page 8 of the paper book. PW1 is the informant, my lord. It seems, my lord, he is a hearsay witness, my lord, PW1. I know accused Radhanath Tati. This is Jagannath Tati is my cousin's brother. Accused and deceased are own brothers. Residents of accused and deceased are situated about 50 meters away from my house. I cannot say how deceased had died. He cannot say, my lord. He is the informant, my lord. About 1 year back, one day in the morning, one Sandan Tati of Seleng Tea State told me that a quarrel fight had taken place between accused and the deceased brother in their house. After that, accused had killed his deceased brother. Chandan also stated to me that accused Radhanath had gone to his house in morning and told him that he had killed his deceased brother. I then, along with Chandan Tati, went to Selenghat outpost and lodged an FIR regarding the said occurrence. Exhibit 11 is my signature. Thereafter, police went to the house of accused and conducted inquest over the dead body of the deceased Jagannath Tati. I also accompanied to the house of accused. I had seen the dead body of the deceased Jagannath Tati. He had sustained injury on his head. Police had conducted the inquest over the dead body of the deceased in my presence. Exhibit 2 is the said report of inquest prepared by police. Exhibit 2-1 is my signature. I had also given statement before magistrate in connection with the said occurrence. Exhibit 3 is my statement given before magistrate under section 164 CRPC. Exhibit 3-1 is my signature. While giving my statement before magistrate, police was present nearby and I gave my statement as stated by Sondon Tati. Cross. I do not remember when the occurrence had taken place. The FIR was written at the police station by one of our co-villagers. I do not know reading and writing. Deceased and accused are my own brothers. We three brothers stayed separately. That means, my lord, all the three stayed separately. My deceased, my lord, somewhere, my lord, I have found, my lord, the accused person and the deceased was stayed in the same house. But here, my lord, he has stayed, my lord, we three brothers stayed separately. My deceased younger brother, Jagannath Tati, had epilepsy and he suffered frequent attack from epilepsy. He used to fall whenever he suffered epilepsy attack. About 15-16 days back of the occurrence, my deceased brother had fallen down due to epilepsy attack. My deceased brother used to stay 15 meters away from my house. His house is situated at an audible distance from my house. I did not hear any alarm, hue and cry of anybody on the previous night of the said occurrence. I lost the FIR as per the version of Sondon Tati. I cannot say whether my deceased brother had died due to fall from epilepsy attack. So, my lord, from this evidence, my lord, we cannot come to a conclusion, my lord, how the deceased died, my lord, from his evidence, my lord. It is difficult to come to a conclusion whether, my lord, the deceased was died due to, my lord, injury caused by the, my lord, by the accused or, my lord, due to epilepsy, my lord. Had there been any quarrel, my lord, as he is in an audible area, my lord, he has not heard, my lord. That is very much clear, my lord, from his evidence. PW2, my lord, he only on the basis of this, my lord, PW2's, my lord, evidence, my lord, conviction was, my lord, here. PW2, Sondon Tati. I know accused Radhanath Tati. He is my co-villager. I also know his deceased brother, Jagannath Tati. About 10 months back, one morning, accused Radhanath Tati came to my house and told me that on the last night, he along with his deceased brother slept together, but in the morning, his brother, Jagannath Tati, did not woke up from his sleep. He then asked me to go along with him. After going there, I found a lot of villagers gathering in the house. After some time, brother of the deceased Gopi Tati came to the house of deceased Jagannath Tati. Then accused in front of all villagers confessed that he had killed his deceased brother by a stone meant for making paste of spices. My lord, here, my lord, I am pausing for a moment, my lord. Here, my lord, this the PW2, my lord, he has deposed, my lord, the accused confessed, my lord, that he had killed his deceased brother. My lord, but my lord, regarding, my lord, this confession, my lord, the police during investigation did not send him for, my lord, recording confessional statement. And my lord, and here also, my lord, nothing is clear, my lord, before whom, my lord, who were the persons before whom the, my lord, their names were not mentioned. And my lord, even, my lord, other witnesses also, they have not supported this version, my lord. But, my lord, the trial court, my lord, on the basis of this, my lord, extrajudicial confession, my lord, come to a conclusion that this is committed murder, my lord. My lord, I, along with other villagers, then saw the dead body of the deceased and found that his head was cracked. Accused then stated that he would go to jail since he had killed his brother. We then stopped him from going anywhere as police would come to the said place. Accused also wanted to go to the police station. I, along with Gopi Tati, BW1, then went to Seleng outpost and informed the occurrence to police. Police then come along with us to the house of the deceased and apprehended accused. Police then sent the dead body for postmortem examination. I also came to court and gave my statement before magistrate. Exhibit B is the said statement given by me under section 164 CRPC. Exhibit 4.1 is my signature. My lord, cross examination, my lord. Next page. On the previous day of occurrence, I had gone to my in-laws' house, which is situated at 2 kilometers away from my house. On the morning of occurrence, I returned from my in-laws' house, and after taking tea, I got the same information. I went to the house of accused in the morning of the day of occurrence. The house of the deceased and accused are adjacent to each other. From this evidence also, it is clear that they have living separately. After going to the house of accused, I found his family members. There were only 5 to 6 persons present at the PO. My lord, here I am pausing for a moment, my lord. It is not intelligible, my lord, why police as well as my lord prosecution did not examine the family members, my lord, who live in the adjacent house of the accused, my lord. They were not examined, my lord. There were only 5 to 6 persons present at the PO. The village is quite far from the house of the accused, and the Gaubura of their village did not come since nobody had informed him. I was interrogated by police at the police station on the same day of filing of the FIR. It is not a fact that I did not state before police that on the previous night of occurrence, the accused and his deceased brother had slept together. I did not state before police that the accused wanted to go to the police station. I cannot say whether deceased Jagannath Tati suffered from any disease. My house is situated at about half kilometer away from the house of accused. It is not a fact that accused did not state that he had killed his deceased brother by a piece of stone meant for grinding spices. It is not a fact that due to my inimical relationship with the accused, I had falsely stated about the said occurrence. I cannot say whether deceased had died due to fall as a result of his epilepsy attack. He cannot say. I did not see the piece of stone with which accused had killed his deceased brother. This is important, my lord. After arrival of police, I had seen police taking out the said piece of stone. Deceased was lying on the bed. My lord, here also, my lord, he said, my lord, he is lying on the bed. Some witnesses said, my lord, he was lying on the courtyard. Someone said in the floor, my lord. I did not see any piece of stone on the bed where deceased was lying. When accused stated to me that he had killed his deceased brother, his mother, when accused stated to me that he had killed his deceased brother, his mother and 2 other persons were present in the house. My lord, but these witnesses, my lord, they were not examined by the my lord prosecution, my lord. Neither in police interrogated him, nor my lord they were examined during course of trial, my lord. Accused mother has reportedly died. I do not know the names of 2 other persons. It is not a fact that I have deposed falsely today. It is not a fact that I have not stated falsely that accused told me that he had killed his brother. My lord, PW3, my lord. He is also PW3 is also hearsay witness, my lord. My lord, here she deposed, my lord. She was Dipali Tati, my lord. I know accused Radhana Tati and this is Jagannath Tati. Both of them are my brother-in-laws. We used to stay separately, and the accused and the deceased used to stay together in the same house. This witness said, my lord, they stayed together. About 1 year back, my brother-in-law Jagannath Tati died. Accused Radhana Tati had killed Jagannath Tati. At the time of occurrence, I was in my house. The occurrence had taken place in the house of the accused and deceased. On the next morning of occurrence, I came to know about the same from my cousin brother, Sondan Tati. It is the PW2 Malad from whom she came to know. Malad. Sondan had informed us that there was a fight between deceased and the accused in the last night. But my lord, regarding this fight, my lord, even my lord, Sondan Tati has not deposed, my lord. There was a fight between the 2, my lord, due to some reason, my lord. He has not said so, my lord. After knowing the same from Sondan Tati, we all went to see Jagannath Tati. After going to the house of the deceased, I saw Jagannath Tati lying dead inside their house. I noticed injury of the backside of the head of the Jagannath Tati. We then informed police, and after which Tati's body was taken away. my lord, regarding confession also, my lord, confession before, my lord, confession made by the this accused, my lord. She has not also, my lord, she was, though they are present, my lord, she has not said, my lord, the accused confessed his guilt, my lord, in our presence. In cross, my lord, he has stated, my lord, my brother-in-law Jagannath Tati had epilepsy. He also used to drink a lot of alcohol. I cannot say how Jagannath Tati had died since the occurrence had taken place in their house, which is situated about half kilometer away. So, my lord, this is also from cross, my lord, is clear, my lord. There is a possibility that the deceased may die due to frequent attack of, my lord, epilepsy, or due to, my lord, consumption of heavy liquor, as a result of which he fall down on the piece of stone. PW4, Ramesh Sarak, he was declared hostile, my lord. My lord, he deposed, I know the accused as well as the informant. The accused is my brother-in-law. On the following day of the occurrence, I, accompanied by my wife, went to the house of the accused, and there I saw Radhanath lying dead with injuries on his person. So definitely he ought to have, my lord, Jagannath, my lord. I saw a meted used for grinding spices lying nearby. I put the meted in the vehicle of the police. At this stage, prosecution witness declared hostile at the prayer of prosecution side. It is not a fact that I did not state to police that accused Radhanath had killed his younger brother Jagannath by hitting him on head with a meted. Police seized the meted, and I put my signature in the Caesar list. Exhibit 5 is the Caesar list, and Exhibit 5(1) is my signature. Well, in cross, she deposed, my lord. He deposed, I don't remember the day of the occurrence. I went to the place of occurrence after the arrival of the police. I did not see where from police recovered the meter. Though, my lord, he was my lord, shown as a, my lord, witness of, my lord, the exhibits, my lord, in presence of which, my lord, he is a Caesar witness, my lord. He was projected as Caesar witness, but he clearly deposed, my lord. I did not see where from police recovered the meter. As police asked me, I put my signature in the Caesar list. I don't know what has been written up in the Caesar list. Jagannath had been suffering from epilepsy. My lord, he also, my lord, said the same thing. Jagannath has been suffering from epilepsy. Next, my lord, PW5 is, my lord, not related with the, my lord, accused or the deceased, my lord. PW5, my lord, Sri Shankar Chandra Rabha. Oh, sorry, my lord, he is a scientific officer, my lord. My lord, scientific officer. He said, my lord, I was working as scientific officer at Forensic Science Laboratory. My lord, here, my lord, on the day I received a parcel through director in connection with case number so and so. The parcel one seal cloth cover in a wooden box consists of 3 exhibits enclosed with a cloth cover which sealed with the impression of a seal provided by additional species. After opening the parcel, I found the following articles. Description of the article: 1 stone plate, Kilpota, contains stains of suspected blood, blood sample of deceased in filter paper, and 3 blood sample of deceased in cotton gauze. And, my lord, finally, my lord, he come to a conclusion, my lord. After examining, I found the next page. I found the following result: exhibit number so and so, so and so, and so and so gave positive for human blood of group O. That is his, my lord, my lord, blood group is same of the 3, my lord, report. And
Lordship, may I interrupt? Evidence of PW4, I did not find it on original record. I am going through the original record because I don't have the paper book. It's not on record, Lordship. It's my duty to point it out.
You don't have the paper book.
I don't have the paper, but I have gone through from the record, but PW4's evidence is not on record, Your Lordship. Whether it was misplaced or not. No,
It is there in the paper book.
yes, but in the original record, it's not there, Your Lordship. 3, so 3, 5, 6.
Try to find out later on.
Lordship.
Yes. So the blood serology test is positive.
positive, ma'am.
Human.
Human blood of having
Not human blood, his blood. This is blood.
This is blood, my lord. This is blood
Hmm.
and it, my lord, O positive, my lord.
So the deceased was found dead lying in his bed.
Some witnesses said, my lord, lying on the bed. Some said inside the house, some said, my lord, in the courtyard. Different versions comes out, my lord.
Now, which witness has seen it for the first? Who was the first among the witnesses to
The PW2 man,
see the dead body? He says it was found lying inside the bed.
bed.
So you are saying he fell down on that stone
Silpata.
which was kept in his bed and then he
Yes.
sustained injury
Yes,
and he died.
yes.
Don't you think it is a little too imaginative for the court to accept?
My lord,
Why would someone take that whatever mitate or whatever it is called, put it in his bed,
my
and
lord,
fall there and sustain injuries and die?
my lord, here, my lord, in my lord, somewhere I have found, my lord. His room is also having one room only.
So that is another matter, but the case you are trying to project, if we have understood correctly, that the deceased was a patient of epilepsy,
Yes.
and probably what you are trying to project is that out of a fit of epilepsy, he fell down
Fell down.
on that particular stone piece, mitate or whatever it is called. And that is when he sustained injuries and died, right? After that, how did he come to the bed?
My lord, that is, my lord, different witnesses depose differently, my lord. My lord, my submission is on that.
Whatever, what is your explanation?
My submission is that, my lord. My lord, the prosecution is to prove the case beyond all reasonable doubt.
Oh, when we ask you a question, you go into theories of. We are asking you,
Yes, yes, I got your point.
what is your version? You tell us that.
Yes,
You must have a version, no? What has happened?
yes. PW6, my lord, he is also one more witness, my lord. After going through, my lord, I will give you reply, my lord. PW6, Prahlad Singh, my lord. I know the informant as well as the accused. I knew deceased Jagannath Tati. The incident took place about 1 year ago, around 8 or 8:30 on the day of occurrence. After collecting the money for the goods purchased on credit from my shop, I went to the line of Selanghat Tea Estate where I live. Seeing lots of people gathered in front of the accused person's house, I too went there. The deceased was lying in the front courtyard of the house of the accused. He said, my lord, the deceased was lying in the front courtyard of the house of the accused.
But after that, after he died, his body might have been carried out to the courtyard.
My lord,
When
maybe,
PW6 went there, then he saw he was lying. That is another matter. Mr. Dotto, don't confuse these two things. And you cannot confuse us, but you will be confusing yourself. PW6 said that on hearing about the incident, he came to the house and saw the dead body lying in the courtyard. That is very different from the witness who was the first to see the dead body. He said that he did not wake up in the morning.
Yes.
And then we discovered that he was dead.
And on
That
the
means he
bed.
was in the bed. These are two different, there is no contradiction. Somebody will see it in the hospital. The doctor who had committed postmortem will see it in the forensic department. Can you say that the body was first found in
No.
forensic department? That is something like that you are trying to project.
No, my lord. My lord, it may be, my lord. I'm not, my lord, confusing, my lord. The deceased was lying in the front courtyard of the house of the accused. The grinding stone and the meat used for grinding spices were lying nearby.
Hmm.
It was lying nearby in the courtyard, my lord. The people present there said that a quarrel had taken place between the accused and Jagannath. Police seized the meat and I put my signature in the scissor list. Exhibit 5 is the scissor list and exhibit 5(2) is my signature. I have seen material exhibit 1, the meat in the court today. Like in cross, my lord, he said, I don't remember the date of occurrence. I don't know how Jagannath had died. My lord, I saw lying on the courtyard. I don't know how police made the scissor. Jagannath and the accused lived together. I heard that Jagannath had epilepsy. Once he fell down in the market, Jagannath was a heavy drinker. He was often found lying on the road. He was often found lying on the road. But PW7, my lord, he's the investigating officer, my lord. He said, my lord, on 16/11/2015, I was on duty as in charge of Selanghat OP. The day upon receipt of an Azahar from one Gopitati, I made a GD entry by so and sent the Azahar to Tiok PS for registration of a case. Thereafter, the OC Tiok police station registered a case and entrusted me with the task of investigation of the case. Exhibit 1 is the Azahar and Exhibit 1-3 is the signature of Amrit Singh. The officer in charge of Tiok police station, which I am familiar with, Exhibit 1-2 is my signature with note. The statement of the informant was recorded at the police station on the same day on which the Azahar was lost. Thereafter, I proceeded to the place of occurrence. In presence of a magistrate, the inquest was done on the dead body at the place of occurrence. I drew the sketch map of the place of occurrence. Exhibit 7 is the sketch map and 7-1 is my signature. I recorded the statement of the witnesses at the place of occurrence. The accused was found at the place of occurrence. When the method with which he had killed the deceased was produced. I seized the same in presence of witnesses. Exhibit 5 is the scissor list. Exhibit 5-3 is my signature. I have seen the material Exhibit 1, the method in the court today. The accused put the signature in the scissor list in my presence. Exhibit 5-4 is the signature of the accused. Accused signature was taken in the scissor list. The sample of blood found in the seized article, that is the method, and the blood sample collected by the doctor from the dead body were sent to FSL Guwahati for examination, and thereafter FSL report was collected. The postmortem examination was done at Jorhat Medical College Hospital and PM report was collected. The accused was arrested and forwarded to court. The statement of 2 witnesses were recorded under section 164 CRPC in the court by a magistrate. In the meantime, as the investigation was completed, I submitted charge sheet against the accused. Exhibit 8 is the charge sheet. Exhibit 8-1 is my signature. Exhibit 9 is the extract copy of GD entry and Exhibit 9-1 is my signature. I recorded the statement of Ramesh Sarok. That he was declared hostile. In his statement before me, he stated that accused Radhanath had killed his younger brother Jagannath by hitting on his head with a method. Cross. The Azahar was not written by the informant himself. I have not named the scribe of the Azahar to be a witness. I received the Azahar at 7:40 AM and went to the place of occurrence at 8:30 AM. The distance between the place of occurrence and the police station is about 2.5 kilometers. The incident took place on 15/11/2015. The Azahar was lost in the morning hours. At night, we did not receive any information about the incident. The informant deceased and the accused are brothers and they live separately. Here also said they live separately. I did not find the family members of Jagannath and Radhanath. Jagannath house is a 2-roomed one. Going there, I found deceased lying in his bedroom. He was lying supine on the floor and his body was in a bent position. From his evidence, my lord, who conducted the postmortem and
So the incident appears to have happened in the courtyard. Then the
No, but the sketch map says it was inside the room.
inside the room.
Yes.
here also inside the room, lying in his bedroom. Here it is. Jagannath's house is a 2-roomed one. Going there, I found this is lying in his bedroom. It is not said he is on the bed, lying on his bedroom. He was lying supine on the floor, and his body was in a bent position. From this, my lord, I am submitting, my lord, due to attack of epilepsy, my lord. He may, my lord, fall down on the, my lord, heel bottom. I saw injuries in the deceased head. The method was lying near the deceased. I found only the method near the dead body. While making statement before me, Sandan Tati did not state that on the previous night of occurrence, accused and the deceased had slept on the same bed. In his statement before me, Sandan Tati also did not state before me that the accused person expressed his willingness to go to the police station. The place of occurrence, that is the house, is not is not a tea garden quarter, but a self-built one. I did not record the statements of Naga Nayak and Nili Nayak mentioned in this sketch map because I did not find them there. Two houses are shown in this sketch map, but I have not shown any door or window. On the day of occurrence, Sandan Tati was not at home. Sandan Tati, PW2. Though the informant had gone to Amguri on the day of occurrence, he returned home at 9 p.m. that day. In the Azahar, it is mentioned that incident took place at night, but time is not mentioned herein. The witness did not state before me that the deceased was suffering from epilepsy. It is not a fact that I have submitted charge sheet without doing proper investigation. And last one is the doctor, who conducted the postmortem, PWV. He deposed on 16/11/2015. I was posted at Jorhat Medical College and Hospital as demonstrator in the Department of Forensic Medicine. On that day, I performed postmortem examination on the dead body of the Jagannath Tati, alias Govinda, 22 years male, with reference to Selanghat outpost, GD&T number so-and-so. That body was brought and identified by so-and-so. I performed the postmortem examination on the same day and found the following. Here, my lord, if your lordship, my lord, just from the page 72, my lord, it will be where, my lord, the injuries, my lord, is clear, my lord, from page number 72. Page 72, my lord. Last paragraph. Injuries suffered by the deceased, my lord. Laceration of size 7 cm into 1.5 cm is present over the right peritoneal scalp, parallel to the sagittal fracture. The margins of the wounds are irregular and antemortem. Blood clots adherent visceracies washing with deep water. On reflection of the scalp found contused and fissured fracture of temporal bone present.
There were 4 different injuries. How can somebody get 4 injuries falling down somewhere?
My lord, but on the right peritoneal area, my lord. Injuries on the right peritoneal. All the three injuries are on the right peritoneal area, my lord.
Both the sides of brain, if I'm not wrong.
My lord, because, my lord, first one, my lord. Laceration of size 7 cm into 1.5 cm is present over the right peritoneal scalp, right peritoneal, parallel to the sagittal fracture. And the second was also laceration of 3 cm into 1 cm, soft tissue depth present 1.5 below the injury number 1, just below the injury number 1, my lord. And third one is also, my lord, laceration of size, my lord, 3 into soft tissue depth is present behind the right ear, my lord. All are in the same side, my lord. It's not that, my lord, different sides, my lord.
Scalp, skull, and vertebrae, that's the membrane.
Membranes congested, subdural hemorrhage present in both sides of the brain. Subarachnoid hemorrhage present over both sides of the brain, my lord. Lord, this is, my lord, after the injury, my lord. The membranes, my lord, it was congested, my lord. So, my lord, these are the, my lord, these are the witnesses, my lord. And the doctor opined that as to the cause of death, opinion is as to the cause of death, death was due to coma as a result of the injuries sustained on the head of the deceased as described. All the injuries were antemortem caused by blunt force impact. Approximately time since death 12 to 24 hours. Exhibit 10 is the postmortem report, where exhibit 10(1) is my signature. Across, my lord, the injury is very unlikely caused if the victim falls on the hard object. I have not found any disease while conducting postmortem on the body of the deceased. I have not found any symptoms of epilepsy on the deceased during my postmortem examination. My lord, from my submission on this, my lord, the whether, my lord, examining, my lord, postmortem, my lord, conducting the postmortem, whether it comes out, my lord, whether he has been suffering from epilepsy.
No,
or
but
not.
he says it is unlikely to have been caused by falling down.
The injury is very unlikely cause. Very unlikely cause if the victim falls on the hard object. My lord, that is there. His statement is there. But my lord, other witnesses, my lord, from the other witnesses, my lord, they said, my lord, they have been suffering from epilepsy. Though, my lord, he at the time of conducting the postmortem examination, my lord, he found, my lord, while conducting the postmortem, he has not found any symptoms of epilepsy. But, my lord, I don't think, my lord, while examining a dead body, my lord, he will, my lord, come to a conclusion.
So what
that
is
he
your
has been suffering.
submission? What is
My
your
lord, my submission is that, my lord, he was, my lord, he was an alcoholic and he was also suffering from epilepsy. And that's why, my lord, he probably, my lord, he maybe, my lord, due to sudden attack of epilepsy or due to, my lord, under the intoxication, my lord, he may fall down, my lord, because from the deposition of the, my lord, police, my lord, who, my lord, conducted the inquest and all, my lord, he, my lord, very clearly said, my lord, Jagannath house is a two-roomed one. Going there, I found this is lying in his bedroom. He was lying supine on the floor and his body was in a bend position. So,
What is the basis to implicate the appellant here? Why the appellant was implicated here?
my lord, appellant was implicated because, my lord, on the basis of, my lord, PW2 statement, my lord, on the statement of PW2, my lord.
Yes. What does it
Sandan Tati, my lord,
mean?
PW2. My lord, he, my lord, deposed that the accused person came to his house. PW2, my lord. I am reading again, my lord. I know the accused Radhanath Tati. He is my co-villagers. I also know his deceased brother Jagannath Tati. About 10 months back, one morning, accused Radhanath Tati came to my house and told me that on the last night, he along with his deceased brother slept together, but in the morning, his brother, Jagannath Tati, did not woke up from his sleep. He then asked me to go along with him. After going there, I found a lot of villagers gathering in his house. After some time, brother of the deceased Gopi Tati came to the house of deceased Jagannath Tati, then accused in front of villagers, confessed that he had killed his deceased brother by a stone meant for making paste of spices. And, my lord, when, my lord, the affair was lost, my lord, he was, my lord, dragged in the manner, my lord.
So only linkage is the extrajudicial confession.
Confession.
Yes.
Then thereafter police came, he showed the silpata. An opinion of the doctor, your lordship, and they have taken a plea that he used to consume liquor. But postmortem report doesn't say so, that those materials were found in his stomach. My lord.
So according to you, is it good enough extrajudicial confession?
If it is trustworthy, your lordship, then my
Who is PW2? Is co-village?
cousin, my lord.
Cousin, my lord.
First accused person went to him and informed, my lord. And to PW3 also, Dipali Tati, sister-in-law, to her also, he has informed.
Hmm.
My lord, he got the PW3 got the information from PW2.
Yes, Chandan informed.
Sandan informed.
It is a Chandan, your lordship, who inform everyone.
PW2, my lord.
Falling on Silpata, lordship, so much of injury and death on both the sides. There is nothing to disbelieve, your lordship, the opinion of
What
the
is the
doctor.
motive?
My lord, to that effect, my lord, that nothing has come out, my lord. Tension motive, my lord. Nothing has come out in the evidence.
Some witnesses have said they had fight, your lordship, the previous day.
That is PW3. who has come to know from PW2
Yes, about the fight.
about the fight, but PW2 did not state anything about fight.
And what does he say in his 313?
Yes.
Yes, 313
313,
statement.
my lord.
Page 27.
Page?
Page, my lord,
27 is the answer.
26. Page 26. Others, my lord, whatever he has been asked, my lord, he has replied false, false. Page 26. Last one, my lord. Do you want to say something in your favor? The deceased used to drink a lot of liquor. He may die due to falling on the hill pota on that night. I don't know how my brother died. I don't know why this false case was lodged against me.
So any evidence to show that he was present in the house on that night? Appellant?
No,
No, my lord.
but he himself came. But he himself came to PW2 and 2, my lord, and informed about the death, your lordship.
But when, my lord, that question was put, my lord, during 313, my lord, he denied, my lord. Question number 2, my lord, page 25. PW2 Sandan Tati deposed in his evidence that after hearing the incident, he went to your residence and found that village people gathered in front of your residence, and then you had confessed in front of the village people that you had killed your deceased brother by a stone meant for making paste of spices. What do you say about that? It is not a fact.
And in his 161, did the PW2 say so to the IO? That the-
And my lord, that the question, my lord, regarding, my lord, in 313, my lord, such type of question was not put, my lord, that whether the accused person went to your house to inform that the deceased was,
It is not necessary. That was
not there, my lord.
there was no need to put this question. Read some judgments, you will know what questions, what is to be put to the accused. under
No,
313.
my lord, I am submitting, my lord, because, my lord, lordship was asking, my lord, that.
No,
whether
only the
is there any-
incriminating
That's why, my
materials.
lord, I pointed out, my lord.
Only
Only
the,
the materials, my lord, that
nothing.
need to be asked, my lord, during 30. And it should be very specific.
May I read?
No, is it there?
Yes.
Oh, just read that part.
যোৱা ৰাতি 15/11/15 তাৰিখে মই একে বাগানৰ বৰুৱা লাইনত থকা মোৰ শহুৰৰ ঘৰত আছিলো। ৰাতিপুৱা মই 6টামান বজাত মোৰ ঘৰলৈ আহো। ঘৰ পোৱাৰ পাছত একে বাগানৰ ৰাধানাথ তাঁতী মোৰ ঘৰত উপস্থিত হৈ কয় যে ৰাতি সি আৰু তাৰ ভায়েক জগন্নাথৰ মাজত কাজিয়াৰ সূত্ৰপাত হৈ খঙতে ওচৰতে থকা মছলা পিছা শিলপতাৰে মূৰত মাৰি হত্যা কৰিছে বুলি কয়। তেতিয়া মই পলম নকৰি ৰাধানাথৰ ডাঙৰ ককাই গোপীনাথৰ ঘৰত উপস্থিত হৈ তাক জনাই ওচৰতে থকা ঘৰত উপস্থিত হৈ ভিতৰত সোমাই জগন্নাথক চিনি পাওঁ আৰু মূৰত গুৰুতৰ জখম দেখা পাওঁ আৰু মূৰৰ পৰা তেজ ওলাই তেজেৰে বৈ আছে। মই আৰু গোপীয়ে শিলপতাখন চাওঁতে তেজৰ চেকুৰা লাগি আছে। মোৰ আগতে ৰাধানাথ তাঁতীয়ে মৰা বুলি স্বীকাৰ কৰে। And Dipali Tati, to whom Chandan has said, your lordship, she is the wife of Gopinath.
Who is Gopinath?
Gopinath is one of the brother,
Gopinath is the brother, my lord.
cousin brother.
My lord, three brothers, my lord, Gopinath, Radhanath, and my lord Jagannath.
Gopinath the cousin brother, no?
Gopinath is PW1.
It would have been Chandan's wife, that would have been different, your lordship. She is also saying, your lordship, is before.
Sandan was different, my lord. He
Yes.
was not hailing from his
Yes.
family, my lord. PW1 is Gopi, my lord. Gopinath. Gopi Tati. I know accused Radhanath Tati. This is Jagannath Tati is my cousin's brother. Here it is cousin brother. Somewhere I found, my lord, he is my brother, my lord.
Dipali Tati also talks about that Chandan came to them and informed his husband. inform her husband.
Deepali Tati is 3, PW3.
PW3,
Yes.
Dipali Tati, my lord, I know accused Radhanath and deceased Jagannath Tati, both of them are my brother-in-laws. We used to stay separately and the accused and the deceased used to stay together. My lord, Dipali Tati is the wife of Gopinath, my lord. Gopinath is the, my lord, informant, my lord. And my lord, see, Dipali Tati in her evidence said, we used to stay separately and the accused and the deceased used to stay together in the house, same house. About 1 year back, my brother-in-law Jagannath Tati died. Accused Jagannath Tati had killed Jagannath Tati. At the time of occurrence, I was in my house. The occurrence had taken place in the house of the accused and deceased. On the next morning of occurrence, I came to know about the same from my cousin brother Sandan Tati. Malad is the Sandan Tati on the basis of on his malad deposition, malad. Court has come to the malad conclusion that malad the extrajudicial confession on the point of extrajudicial confession, malad, the court malad convicted, malad, and court also malad while trial court malad convicting the accused, malad, the court has given a reason that as the police, as the doctor during post-mortem did not find any anything about epilepsy. So, my lord, that version, that epilepsy that was discarded by the trial case, my lord. So, my lord, the circumstances, my lord, he says, my lord, arising in the instant case, my lord, do not, my lord, unendingly, my lord, pointing towards the guilt of the, my lord, accused. All right, is one of my submission, my lord. And my lord, he may die due to, my lord, epilepsy or due to, my lord, alcoholic, my lord.
We'll see what
Yes.
PW2, 3
Yes.
and
Only
homicidal
PW
death.
1, 2 and 3. And is leading to discovery.
My lord, I have want to rely
In the
on
opinion of the doctor, your lordship.
Just 1 minute.
Yes.
Yes, what judgment?
My lord, should be aware, my lord, just, my lord, I want to place one Devilal versus State of Rajasthan.
What is the law?
My
What
lord,
is the
there, my lord, the law says, my lord, it is the settled law, my lord. My lord, when, my lord, in a case of circumstantial evidence, two views are possible on the case of record. One pointing to the guilt of the accused and the other his innocence. The accused is indeed entitled to have the benefit of one which is favorable to him. My lord, my submission is that, my lord, here, my lord, two types of evidence has come. My lord, he may die due to falling of, my lord, heel pota or due to attack
Now,
of
where is the
epilepsy.
evidence to show that he may die due to falling in Shilpata? Which is that evidence?
My lord, all the witnesses, my lord, said, my lord. My lord, he has a, my lord, he may die, my lord, has a, my lord, he has been suffering from heel pota, my lord, suffering from, my lord, epilepsy, my lord. And, my lord, so, my lord, that may be
All right,
happened, my lord.
apart from that,
Apart from that, my lord, whether it is on the circumstantial evidence or direct, my lord, the prosecution is bound beyond reasonable doubt. It is required to be proved. So, my lord, it is in this case, my lord, it is not proved beyond all reasonable doubt. My
you want to add anything?
Don't have anything.
We'll
Except
have
your
to
lordship,
see
the prosecution could prove.
whether we agree with his submission or not. We'll have to see whether each link in the chain of circumstances whether it is established that if you take away PW2,
Yes,
there is nothing.
nothing
Yes.
Question is, to what extent PW2
is believable.
is believable? What is the motive? Nothing has come.
161, they say they used to fight, your lordship, after consuming liquor.
Where 160?
161.
But then it is not in the evidence.
Admittedly, this accused person is sleeping with the deceased man. There should have been.
Who has admitted that?
No, he only came to Chandan. That is after it comes down to Chandan only. Comes back to Chandan, my lord. If Chandan is believable, then lordship may appeal the conviction.
Only Sandan said he was slept
He's
with
the one.
the accused. Only Sandan said, my lord, he was the accused, deceased and the accused slept together.
That's right. So if we find that Chandan's testimony is believable, finds corroboration,
Yes.
then why not? We'll affirm the conviction. But if we find that there is some doubt, some contradiction, then of course, we have to hold that the prosecution.
My lord, Sandan's statement is not believable. Because why I'm submitting so much? Because Sandan said, Lord, the accused person confessed his guilt before the public and before him and the other public. But my lord, other witnesses, my lord, who have been examined, they have never said that the accused person confessed his guilt. So, my lord, that confession, my lord, extrajudicial confession, that cannot be, my lord, relied on, taken into consideration. Because, and if, my lord, other witnesses say so, then, my lord, it would have, my lord,
Mr. M. Doctor, counsel, and amicus to be appearing to the appellate. We also had Ms. B. Leon, senior counsel, bracket APP Assam. Wicket close, assisted by Ms. Chakravarti, Level counsel for the speech. None has appeared for the informant. This argument concluded, judgment written.
obliged.
Where is Ms. S. K. Nargis? She had